can we step out?
Yes.
Sorry. Yes, Your Honor.
All right.
I did have one matter when Ms. Redlick is here.
Okay, thank you.
6, State.
Sean Wiggins for the state of Florida.
Jennifer Garcia for the state of Florida.
Defense. Catherine Conlon, along with Andrew Parnell, we represent Danielle Redlick, who's present in the courtroom.
All right, good morning, everyone. We have 8 jurors. Ms. Conlon, you said you had something to present?
Since the state has not started their rebuttal case, we're requesting that the court allow us to reopen the case and call Detective Ware to present to the jury what she proffered yesterday. May I approach with case law?
Yes, please.
The first page is 90.609, which says that any party, including the party calling the witness, may attack the credibility of a witness by, and subsection 5 says proof by other witnesses that material facts are not as testified to by the witness being impeached. School, Dad said to Jaden, "You better have a good lie as to where you have been." This statement shows that at a minimum, Dad was angry. He was upset with Mom by making that sarcastic comment. It shows that her credibility is at issue, and that's the reason why we would ask that Detective Ware be allowed to impeach Jaden's testimony where she denied ever hearing that, because it's clear that she actually, Detective Ware said that Jaden made that statement to her. As far as the Emmy's testimony that she never told law enforcement that Michael Redlick bled out within 5 to 6 minutes, that was contradicted by Detective Ware, because the how long it took Michael Redlick to die is certainly a material issue in this case. The longer it took, and she, as in the medical examiner, testified that it could take hours, it's material to impeach that at one point, she actually told Detective Ware that Michael Redlick bled out within 5 to 6 minutes. Dr. Zadovich, she denied on cross-examination that she ever said that Michael Redlick died within 5 to 6 minutes. And whether or not Michael Redlick died either quickly or slowly is a material issue in this case. For the court, I have provided Butler v. State. In this case, the defendant in the case testified at trial that the victim had invited him over. And furthermore, that he went there to pick up his clothes. The court allowed an officer who was a supervising officer of the 2 officers who were on scene, who had looked through the house to see if there were clothes in the house that belonged to the defendant. And these 2 officers had told the supervising officer who testified at trial that, no, we didn't find any clothes. So that officer, so we have hearsay, that officer was allowed to actually impeach the defendant who had stated, "I was invited over." I've also provided the last case, which is Spindler v. Brito DeForge, 762 Southern 2nd, 963, that the shifting sands of a trial may cause a judge to rethink an earlier evidentiary ruling based on a matured understanding of the case. For those reasons, we would ask that under 90.608, subsection 5, that we be allowed to have Detective Ware testify as to what she proffered yesterday. The state, sorry.
No, you're not finished. I have a question when you finish your presentation.
So the argument yesterday was that the foundation was not laid, and that was what the Pierce case was about. We were not proceeding under subsection 1. Under subsection 1, which is introducing statements of the witness which are inconsistent with the witness's present testimony, that would have required the foundation. That would be if, let's say Jaden Redlick had given a deposition and I was trying to impeach Jaden Redlick with her deposition. And at that point, I would go through the impeachment process, as I think the court mentioned yesterday. That is not what we were trying, that was not how we were impeaching yesterday. How we were impeaching yesterday was we already had the statement that Jaden made. Now we're bringing in Detective Ware to contradict Jaden's statement as well as the medical examiner's statement at trial.
As to, so there are two statements, basically. One is Jaden's testimony regarding you better have a good lie as to where you've been. And then the second one is Dr. Zagovich stating that it took hours for the victim to die instead of the 5 to 6 minutes for the victim to die, which is what she originally told Detective Ware. So there are two
Yes, it's
issues? Okay.
those two issues, and I just want to clarify for Dr. Zadovich, is that what she testified to, what I asked her was, did you tell anybody that Michael Redlick died within 5 to 6 minutes? Her response was no. So Detective Ware, I would expect, well, that was her proffer, that she had been told by Dr. Z that she, as in Dr. Z, said that Michael Redlick would have bled to death within 5 to 6 minutes. And these are both material issues in this case.
Okay. What I wanted to know, as it relates to Dr. Zagovich's statement, whether, you said whether he died quickly or slowly is material. Can you just explain how the timing is material for your presentation?
So the reason why it's material is because the testimony from Ms. Redlick was that after the stab, she ran into the bathroom and that she hid in the bathroom for a while. So if Michael Redlick was dead within 5 to 6 minutes, it brings more credibility that when she came out, he was already dead, if that makes sense. Now, if the ME also said it could take hours for him to have passed away. So as Ms. Redlick testified, after the stab, she went into the bathroom. And if the ME's statement or testimony is correct, then when Ms. Redlick came out, presumably Michael Redlick would have still been alive. So we're attacking how long it took, the credibility of Dr. Z's, I'm sorry, I'm using Dr. Z because it's hard to say Dr. Zadovich. So the timing of it is material in this case.
Okay. What about the statement from the victim where Jaden is saying, my dad said, you better have a good lie as to where you've been? How is that material?
So the way Jaden, her testimony, she testified that on January 10th, which was the Thursday, that her dad was very angry, he was visibly upset. However, it changed. On January 11th, her dad was apologetic to her, was loving, he was calm, and the way she viewed the interactions between how Michael Redlick was acting on that day with Danielle was that things were calm, he was back to his old self, he was very nice. This statement undercuts that presentation or perception of how dad was acting. Because if he's making a statement such as, you better have a good lie as to where you've been, it shows that he was still angry from the previous day and that it continued.
None of what Ms. Conlon has said has actually addressed the issue that caused the court to deny the request for impeachment. Ms. Conlon has just come before you and cited to 9608, and she said that we're going under subsection 5. Subsection 5 is the introducing material facts that are not what the witness testified to. So, for example, the witness says the light was red, and you bring in a witness to show that the light was green, or, the car was speeding versus the car was not speeding. You introduce material facts to impeach another witness's testimony. Ms. Conlon is still proceeding under subsection 1. She still wants to introduce statements via another witness for the purposes of impeaching the other two witnesses, Dr. Zadovich and Jaden's credibility. So we're not in any way, shape, or form out of section 1, which to the extent that we're not out of section 1 at all. The fact that she's trying to do it through an extrinsic piece of evidence, that is another witness testimony, still requires that she had done a proper impeachment predicate on the front end. She hasn't fixed that. In any way, shape, or form, she can't fix it because she failed to do it when she had the opportunity to do it. And saying I'm not introducing a deposition to do it, I'm doing it through a witness is no different. It's still under subsection 1, it still has the same requirements. The court's ruling is still proper, and if you just look at the language of 5 and then you look at the case, you see that what she's been arguing to you doesn't address the actual issue. The case she cites talks about the defendant testifies to one thing, and they bring in multiple officers that testify to different facts. He had his cell phone. There was, a person over here instead of over there. That's not what they're doing. So, and again, although the court, Ms. Conlon is correct that the court can reconsider a ruling, the court has ruled. And I think it is, I do respect the defense's right to preserve a record, but the party should respect the court's rulings.
Talk to me, Mr. Wiggins, about materiality and Dr. Zadovich's statement. Would it not be material if there's a difference between him dying in 5 to 6 minutes versus him dying in a few hours? Would that be material?
It isn't. Materiality is not the issue. That's not what should change the court's ruling. That may be.
Ms. Conlon is saying Section 5 of Rule 608 is applicable, and she's made the argument that the difference in how long it took for Mr. Redlick to die is material, and she explained why.
Yeah, so we're.
And so what I wanted to know, just on that particular issue, assuming 5 is still legitimate, answer why is that not material?
Because we're misunderstanding what the language of 5. So what she is doing is introducing a statement to impeach the credibility. She's saying Dr. Zadovich said one thing on the stand, and she said another thing at another time. She's not, what she could do under 5 is call their own ME, their own expert. And if this was some issue that they thought was very significant to the defense, and there was the potential for either the doctor not to testify consistently, or they wanted to make sure they established these facts, they would call a witness and they would establish through evidence, because impeachment is an evidence, and that really should get to the heart of this. She is attempting to do an impeachment with a statement, and that goes to credibility and is not substantive evidence. This is the talk about you can offer evidence, material evidence, that also serves as a basis to undermine the witness's testimony. So she wants to call her own medical examiner and have that testimony. That would be proper under 5. But she is offering statements, not evidence. And so we're still under 1. Whether that statement is super important, it's still a statement, and it's not other evidence.
Let me read your cases, Ms. Holland, and I will be back. Your recess. so much for your patience. I appreciate it. As it relates to Detective Ware testifying regarding Jaden's statements about not hearing the father say, "You better have a good lie as to where you have been," the court is not going to allow Detective Ware to testify regarding that. As it relates to the medical examiner telling Detective Ware initially that it took the victim 5 to 6 minutes to die versus a couple of hours or a few hours to die, I will allow Detective Ware to testify regarding that. Statement made by the ME that he died 5 to 6 minutes after having been stabbed. So the witness, Detective Ware, can testify as to the 5 to 6 minutes time of death versus the couple of hours for the time of death, but not testify as to the statement regarding "you better have a good lie" as to where you have been. I am going to allow the defense to reopen their case. Mr. Wiggins?
Could I just speak to that point, Your Honor?
Yes.
We're about to call Detective Ware, so maybe just so we're not, they're reopening a case, they call her for that one point, and then then they rest, and then I call her again. We could just call her in our rebuttal and allow them to engage in that questioning in their cross-examination. It would have the same purpose and effect and not do this sort of awkward situation.
Well, let's see. Defense, Ms. Conlon?
That's fine.
That's fine? Okay, well then I will allow you to ask your questions that way. Anything else I need to take up before we get started?
No, Your Honor.
Nothing from the state, Your Honor.
Okay, Ms. Redlick, I know you've been sitting here for about 45 minutes or so. Do you need a break?
I'm okay, Judge.
You're okay?
Yes,
All
thank
right
you.
then. So let's bring in the jury. But before I do that, did you all look at the instructions? Mr. Parnell, I got your response. Ms. Garcia, you might be able to look at it while Mr. Wiggins is doing his rebuttal. Let's bring in the jury, please. Good morning. How is everyone? Good, good. Okay, anyone watch the news last night about coverage from the case? Shaking heads no. Do any research? Visit any places involved? Everyone's shaking their heads no. All right, we will begin. Mr. Wiggins, Ms. Garcia.
The state calls Detective Pamela Ware to the stand.
Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Detective Ware.
Good morning.
So during the course of your investigation, at any point in time, did you learn about divorce proceedings?
I did.
And who initiated the divorce proceedings?
Ms. Redlick.
Permission to approach, Your Honor?
Yes, ma'am.
Let the record reflect I'm showing opposing counsel with record identification states A.I. I'm handing the witnesses from record identification as states A.I. Do you recognize states A.I.?
I I do.
And what is state's AI?
It's a court paperwork for dissolution of marriage.
And is this the divorce proceedings that you became aware of during your investigation?
It is.
Your Honor, at this time, the state offers what's been marked for identification as state's AI into evidence.
Any objection?
No objection.
AI will be admitted as the state's next numbered exhibit.
State Exhibit 64.
Permission to publish, Your Honor.
Yes, ma'am.
And number, let me see if I can focus some channels. Under number 16, the durational alimony, can you read, starting right here where it says wife?
Wife is without funds with which to fully support herself without this assistance, considering the standard of living established during the marriage as well as other factors set forth in applicable Florida statutes.
And then down here, on number 20, could you read this to the jury?
Exclusive use of marital home.
Okay. And then starting right here, can you start reading where it says wife?
Wife needs the exclusive use of this home and the contents thereof both now and in the future for herself and the minor children.
So moving to this page, can you tell the jury what was her employment status?
She was unemployed.
And then finally, can you read to the jury what the defendant listed as total assets?
It looks like $1,095,500.
Now, Detective, during your investigation and the course of this investigation, and actually after the investigation was over, did you have an opportunity at any point in time in order to obtain and listen to some jail phone calls which the defendant made?
I did.
And I know that during your direct examination, there was in-depth conversation about you had multiple opportunities to speak with the defendant. Is that correct?
That's correct.
So you know what the defendant sounds like, right?
Yes.
Permission to approach?
Yes, ma'am.
Showing counsel's marked identification states G. Marked identification states G. You recognize states G?
I do.
And how do you recognize states G?
My initials and a date is on top of it.
And on this USB, are there 2 jail phone calls?
Yes, there are.
And did you have an opportunity to review these jail phone calls prior to coming to court today?
I did.
And are these jail phone calls, is it the defendant's voice on those jail phone calls?
It is.
And you recognize that as the defendant's voice?
I do.
On both of those phone calls, correct?
Yes, on both.
Now, Detective, and Your Honor, this time, I'm going to be asking to publish during this next set of questions what's been admitted as State 6. I'd like to go back to the search of the defendant's home. When the search was being done of the kitchen, were the drawers in the kitchen searched?
Yes, they were.
And were photographs taken and documented of anything of note and of value?
Yes, they were.
And when you were looking, you and the CSIs, when you're looking through the kitchen, were you looking for knives in those different drawers?
Yes, we were.
So first, let's talk about the drawers in the island, because there was the island where it had the flat cooking top. Did you open any of those drawers?
Some of them, but some of them couldn't be opened.
Some of them couldn't be opened,
No, they were decorative.
so they weren't real drawers.
Correct.
Now, let's move on to, you said that you were looking for knives in the kitchen, is that right?
Yes.
And if you found any knives, did you document the location of the knives in the drawers?
Yes.
And did you find knives in a drawer?
Yes, we did.
And did you find it in one drawer or multiple drawers?
It was one drawer.
Okay, so you looked in all the drawers and you found knives in one drawer, is that correct?
That's correct.
And it was documented with a photo, is that true?
Yes.
Connecting now. And Detective, is this the drawer that you located the knives in?
Yes, that's the drawer.
So this is the only drawer in the kitchen that had the knives, correct?
That's correct.
And for the record, this is photo 3528. And then looking at 3529, is that a close-up of that drawer?
Yes, it is.
One moment, Your Honor.
Detective, you attended the autopsy of Michael Redlick in this case, is that right?
That's correct.
And you spoke with Dr. Zadovich,
That's correct.
and she was the medical examiner who conducted the autopsy of Michael Redlick.
Yes, that's correct.
And you had a conversation with Dr. Zadovich, didn't you?
Yes.
And she told you that Michael Redlick bled out within 5 to 6 minutes, is that correct?
That's what I understood.
That he died within 5 to 6 minutes of the stab wound, is that correct?
That's what I understood.
May I have a moment?
Yes, ma'am.
Detective Ware, do you know the state of the Redlick's finances January 2019?
Yes. We, oh, go ahead.
And what was that based off of?
In the investigation, we had pulled some of the finances to see if they were,
Objection, Your Honor, hearsay, facts not in evidence.
May I respond?
Yeah, come on out.
Detective Ware, you were shown the petition for divorce by the state, weren't you?
Yes,
And you mentioned what the assets were.
that's correct.
And that was back in 2018, is that right?
That's correct.
Thank you. No other questions.
Any questions?
No, Your Honor. At this time, the state calls Annie Jones.
Shall be the truth, the whole truth, and nothing but the truth.
I do affirm.
Could you please state your name for the record again today?
Andrian Leonard Jones.
And the other day, we were talking about jail phone calls and some jail phone calls that the defendant made. I'd like to continue that conversation. So we mentioned that the defendant made some jail phone calls with a different PIN number. Is that correct?
Yes.
And could you remind the jury, and when you're looking for the different PIN number, how do you go about doing that?
Again, I start with the information given by the requester, law enforcement. I start with the PIN number of the inmate that they're requesting information on. I write down or I note the phone numbers that were called using that PIN number. Then I search the phone numbers, also having access to the inmate management system, the system that the jail uses. It says where a person is housed, how long they were there. Knowing that, I know which phones they have access to. It says from the time they were there to the time they leave. So then I know all of the calls that were made using that PIN in those dorms. Again, as I search those numbers, if I find calls made to the same number by a different PIN, I check those calls to verify who it is that's making the call, listening for the inmate to self-identify, say their name, answer to their name, and as I find the calls made by the individual whose calls were requested, regardless of the PIN that was used, I include those in the information that I provide to law enforcement.
So the other day, one of the phone calls that we entered in was a phone call to the number of 440-502-9799.
Yes, ma'am.
Okay. And was that the number in which the defendant was calling to using these different PIN numbers?
Yes.
Okay. So the one call that we admitted the other day, she used her PIN number, is that correct?
It is.
And then she called that exact same phone number using somebody else's PIN number, right?
That is correct.
And the PIN number that was used, was it 19013783242?
Yes,
And did it belong to a Connie Kent?
it did.
Okay, and then did Connie Kent and the defendant, were they housed in the same unit?
They were.
And so the permission to approach, Your Honor? Yes. Showing counsel's mark identification as states G. Handing the witness with mark identification as states G. Do you recognize states G?
I do. This is call information by the inmate requested. When I listened to the calls on here, I verified the calls and I dated and initialed it AJ.
So these are the calls, there's 2 calls on here, is that correct?
That is correct.
And these are the 2 calls in which the defendant made to that number we were just talking to,
Yes,
and they were using that different PIN, is that correct?
that is correct.
And these calls, these are fair and accurate depictions of those calls?
They are.
And these calls are kept and maintained in the regular course of your business?
They are.
Your Honor, at this time, the state offers was to mark identification as states G into evidence.
Any objection?
We'll renew our pretrial objection to this evidence.
The objection is overruled, and G will be admitted as the next numbered exhibit.
State Exhibit 65.
Commissioner Pelchar.
Yes.
So let's talk about the first phone call. The first phone call, was that made on May 29th, 2019 at 9:18 PM?
That is correct.
Judge, may we approach before the publication?
Okay, ladies and gentlemen, I'm going to read to you an instruction on listening to a recording. Members of the jury, you are about to listen to a recording, 2 recordings. The court instructs you that the recordings have been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recordings have been edited should not concern you in any way and must not impact the way you listen to and consider the evidence.
So we're going to listen to, once again, that first phone call, May 29th, 2019 at 9:18 PM.
Yes, ma'am.
For English, press 4 select. Please enter your top. Please enter the area code and phone number you were called. Please hold. Please wait while your call is being connected. Please hold. Hello, this is a prepaid call from. Mommy, this is Connie, your mama.
I'm going to pause it right there for just a second. So this is the prompt. We obviously didn't hear Danielle. Is that because it's that different PIN number?
Yes, the person said their name, Connie.
at the Orange County Corrections. To accept this call, press 0. To refuse this call, hang up or press 1. To prevent calls from this, your current balance is $21.95. This call is from a corrections facility and is subject to monitoring and recording. Thank you for using Global Tellink. Hello?
Hey, please. Did that come through weird?
Yeah.
Well, don't worry about it. So can you talk for a minute?
Yeah.
Okay, are you sure?
Yeah.
You're out now, huh?
No, I'm home.
How's it going? Nice. Visit?
Yeah, so far.
Yeah.
A lot of back and forth, but
Yeah, did you get in the city at all?
yeah, a little bit of it.
Alright, well, I won't waste your time too much. I, wanted to kind of just like share with somebody stuff, for both tampering. They had another student charge there, tampering, because there was so much, I need to say it, there was so much blood when I was trying to, anyway, without saying a lot. I was clipping on it, so I used towel. They're saying, you know, that kind of thing to be tampering, so that's kind of BS, but, you know, it's like, could you consider, you know, whoever. So I don't know what happened between then and there. There's some evidence they keep getting, but I saw it, it's just stuff they took out of his desk when he was writing down stuff about when I had filed for divorce. Michael was so angry, keeping a log of stuff, like, you know, he was just being addictive, like, oh, today Danielle did this, and it's like, all of this stuff is asshole into me, you know, it's like, at one point he was such a freaking, oh, it was awful. The point is, I tried to get out of the divorce. He dodged a freaking, serve, you can serve somebody, you know, and, I tried to serve him 3 times, they couldn't get him, they finally came, and I detected him at the end, he was at the house, you know, the last final serve. You know, I should have just wished I had gone through the divorce. What they're trying to do is get evidence, or they're trying to make this a non-self-defense. They put a motion for non-self-defense, which is horrible.
I read that, yeah, I heard that.
I mean, this just please, I'm dead in the water all the way around all this stuff. He got so angry because I wanted to get out of the relationship, because I had finally had enough at, like, what, 5, 6, 8 years ago? And then when I finally filed for divorce, it was, what was wrong with it? So, today I was so smashed by that, because they gave me more for they took the divorce book. I kind of sat on it and I'm thinking, you know, I should have left. What I did take responsibility for was I should have left. You know, I should have finalized the goddamn divorce, and for not leaving sooner that night, for not leaving sooner, period. It got so bad. Maybe since his life is gone, I can take some kind of, you know, he's just Mr. Nice Guy, just Mr. Perfect, that just, this woman just went off the deep end. I'm not saying that I didn't have freaking problems. I'm not saying that he didn't drive me. The last 6 years were awful. You know, I started declining. I tried to help this man. I carried the brunt of the emotional shit on my shoulders the first 10 years when he started to deteriorate. Now, when he lost it, he had ED, he lost it. And you know, Michael was big freak, even though he was successful. That fucking killed him. It killed him, like, emotionally. He started, like, resenting me, and he didn't want me to leave, but at the same time, he would treat me badly, and not in a loving manner, in a stupid, selfish, sophomore male way that he thought was, you know, I could go on. I tried to explain some of this to you guys back then, I don't know if it made any sense, but long story short, it's like they're leaving me with this, I'm already degraded, I can't see my kids. They never talk, I don't know how they are, they're out of school.
Oh, I talked to Teresa Malay yesterday. She probably had to call back, but,
well, my lawyer said something today about, somebody trying to do something for your guardianship.
I think she's
My
working
first
on
one
it.
was definitely before I could win. I don't think. And your testimony they would use, however, you gotta be
well, she said,
honest with it.
did Matt come to see you yet, the board?
No, and I'm worried about that too. I don't know what he's up to. Because I know that my lawyer called him and was like, hey, back off. So I don't know if he wants to talk to me or if he's just like, you know, shooting shit. He's keeping his little nut in his pocket from Danielle and shit. I don't know. He's washing his hands of it. I have no idea what he's doing, like, because Teresa said I handled that for free. What I wanted him to do is protect my interests, which if he did, great, but if he didn't, I'm taking on that.
Yeah, I'll call him tomorrow. Last time I talked to him, he updated me on things that several matters in the computer, but I don't know.
Because beginning of May, my friend sent her boyfriend over there, and I was trying to find out who was over there, and I wanted to have a conversation with him. But,
I'll email him as soon as I have a computer, just to make sure if I know what's going on. Did you get your money?
it looks like there's money in there, yeah. Thank you. We just had a shakedown after reading these took nothing. But,
So you didn't get to go to the store?
no, I'm going. I'm gonna go order it now. I have time. I saw that there was money in there. I started looking at it. Yeah, thanks. I don't know what you had to do for that or if that helps, but.
Also, there's about something I ordered you, the one you asked for.
Oh, wow. Okay, that's perfect. I mean, I feel like I can't eat now, but I have to have something in there. No, I need to invite my baby too. I've been praying on no prison time. Maybe I'm praying for the wrong thing. This is a confidential call. It's probably, I mean, as far as I know right now, don't ask me how, but whatever you can say, I'm saying, you could, I need to know how to handle this, please. I'm thinking about writing a letter or saying stuff, you know, like.
So the dating morning.
That morning, the dating site, I Googled how to split word, and that was up in the browser. Oh, it's not there. But that was, I don't know, I can't. I don't want to risk too much, but,
Yeah, I saw that in all the paperwork here. I saw all that in
but it's not,
the motion.
I could able to, do my, like, if I was on the outside, I could have a call with you like this, it'd be okay. We could talk better, I could run the soldiers for me, you know? What they did is they went out and they just did this, like, bang out fucking untouchable, job. With me, locked up.
So let's move on to the next call. The next call was on May 30th, 2019, starting at 10:58. Is that correct?
Yes, it is.
And that was to that same phone number, that 440-502-9799?
Correct, yes.
Okay. So that same number that she had called with her regular PIN, she's now calling with this other PIN?
Correct, yes.
For select, please enter your 12-digit TID number. Please enter the area code and phone number you will. Please hold. Hello, this is a prepaid call from
Mommy, this is Connie, your mama.
an inmate at the Orange County Corrections. To accept this call, press 0. To refuse, your current balance is $16.34. This call is from a corrections facility and is subject to monitoring and recording. Thank you for using Global Telly. Hello?
Came out and like, and so we can't hear this phone. I could have called family members, I could have started, working my own, you can't work a case in here. Not that it was, whatever. But I could, like, when I talked to Jim Taylor didn't say it right. But Jim loves me too. I talked to Jim Taylor, not even saying, I'm just telling you, don't do it. And as soon as I said anything else, I said, okay, well, Jim, let's make this statement about this, statement. Jim, that's not that I felt like we could have conversation with me or not. Fine, but to say, look, you're going under oath, on our, like I said, that's conversation, you know what I mean? Like, and there's still other stuff that if we waited this out or investigated more thoroughly, or questions were asked properly, Or if Eric Barker was the first one that told me, I don't know that this looks like self-defense, you might have to reposition this. He knew that right at the beginning, and I told my lawyer. And my lawyer now is sitting with them, telling them, oh, it's not self-defense. I already told him this months ago.
I mean, it's like you either have to decide if you're going to take this plea that they're telling you is good, or you take your chances with the jury and you could possibly get life, or, I mean, that's a lot to sit on, and I don't know.
I don't think I'll get life because they can't, it's not second degree, but they'll see that it's not second degree murder. You don't murder someone in an armpit. That was more of a.
I know, but I just.
Something when it was self-defense, and it was a struggle, and it was what they're saying. They'll see that it's not second degree murder. You don't murder someone in an armpit. That was more of a.
I know, but I just.
It was self-defense, and it was a struggle. And
Got this. Okay.
I don't know if this looks like self-defense, you might have to reposition this. He knew that right at the beginning, and I told my lawyer. And my lawyer now is sitting with them, telling them, oh, it's not self-defense. I already told him this months ago.
I mean, it's like you either have to decide if you're going to take this plea that they're telling you is good, or you take your chances with the jury and you could possibly get life, or, I mean, that's a lot to sit on, and I don't know.
I don't think I'll get life because they can't, it's not second degree, but they'll see that it's not second degree murder. You don't murder someone in an armpit. That's more of a.
I know, but I just.
Something when it was self-defense, and it was a struggle, and it wasn't what they're saying.
No further questions of this witness, Your Honor.
Mr. Parnell?
Mr. Jones,
Yes, sir.
the time she's been in jail, do you know how many calls she has made?
I don't know that number.
Nothing further, Judge.
Any redirect?
No, Your Honor.
Mr. Jones, you may step down.
Thank you.
Stage your next.
to the state, while the defendant may have the burden of going forward with evidence of self-defense, the burden of proving guilt never shifts from the state, and this standard broadly includes the requirement that the state prove that the defendant did not act in self-defense beyond a reasonable doubt. Also, there is no evidence that at the time of the incident that the act was committed with a depraved mind. Here, what we have is Danielle Redlick, who has taken the stand, and she has testified that this is a self-defense case. She has testified as to what transpired on January 10th, 2019. The text messages are in evidence. They corroborate the fact that Ms. Redlick had to leave the home, that Michael Redlick was getting violent, he was getting drunk, and so she had to leave the house. The text messages between her and Sawyer show that she had to have her son tell her when Michael Redlick was asleep and out and passed out, so that it was safe for her to actually sneak back into the house. On January 11th, this hostility still continued. You have Ms. Redlick's testimony that Michael still felt betrayed. You have voicemails that show that he was upset. There was also Jaden Redlick's, the extrinsic evidence that showed that on the day of the incident, Michael Redlick was still upset by this betrayal. He said to Danielle, you better have a good lie as to where you've been. That shows that he was still thinking about the betrayal that he discovered on January 10th, 2019. We also had testimony from Pete Diebel, who said that on the night in question, he was at a game with Michael Redlick and observed the demeanor of both Michael Redlick as well as Danielle Redlick. Michael Redlick was distracted, and what he wanted to do was to go home. Danielle Redlick was quieter than normal. So this is all consistent with self-defense. There's been no evidence set forth to disprove that on the night in question, Ms. Redlick did not use self-defense. So for those reasons, we would ask for a judgment of acquittal. I would also like to add that in Wiley v. State, 600 Southern 3rd, 588 Florida 5th DCA, it states that extreme reckless behavior itself is insufficient from which to infer any malice. Moreover, an impulsive overreaction to an attack or injury is in itself insufficient to prove ill will, hatred, spite, or evil intent, which is what you need for second-degree murder. As far as the tampering charge, we rely on our previously stated grounds.
Your Honor, I'd rely on my previously stated arguments. This case is for the jury to decide.
What about her arguments about the evidence being insufficient to rebut the self-defense argument?
Well, that's not a standard. It's just, is there competent substantial evidence to sustain a verdict? And there is. And if we want to go down that road, Ms. Redlick's every statement she made until this trial started that she didn't act in self-defense, standing alone, is enough to create an issue for the jury to resolve. Showing up in trial and telling it for the first time ain't enough.
All right, as to both counts 1 and 2, the court is going to deny the judgment of acquittal arguments. There is sufficient evidence for the jury that the state presented for the jury to find beyond a reasonable doubt that the defendant acted with a depraved mind. And there is sufficient evidence, sufficient evidence to rebut the self-defense argument. So yesterday we talked about jury instructions, and I sent to both of you the instructions that I worked on. Mr. Parnell said he didn't have any objections. Mr. Wiggins or Ms. Garcia, do you?
Your Honor, just for clarification, you just highlighted areas you wanted the parties to just pay attention to make sure that they were acceptable?
Right.
Okay.
And what my concerns were. looking at page number 4, sometimes we say dwelling house, sometimes we just say residence. And I did not know if you had any preference on either one. I would prefer that they be consistent, that we always say dwelling house or residence,
It's acceptable to the state, Your Honor.
to just say one or the other,
It's
or to say both.
either is acceptable to the state. I'll defer to the defense in the court.
Which do you prefer? Do you want to say both, Mr. Parnell, or do you want to say one or the other?
I'm fine with both being in there.
So then I'll leave that. Oh, we had talked about this yesterday. Oh, no, here we go. If you could look at page number 12, what I had highlighted here, I wanted to make sure that the force. So in the second paragraph, what I have highlighted is, or any attempt to commit manslaughter, aggravated battery, or aggravated assault upon or in any dwelling house in which she was present. Is that acceptable to the state?
Yes, Your Honor.
Defense?
Yes, Judge.
And then it was the same issue in this next paragraph. Manslaughter, aggravated battery, or aggravated assault. Any objection, state?
No, Your Honor.
Defense?
No objection.
Okay. On page number 13, I highlighted 776.013. I could take that out. Wanted to make sure that we understood that that particular section was for basically the castle doctrine. And so you want to keep that one in state?
Well, I'd like to remove the statute.
I did.
Okay. And we're pulling this language from the standard,
Yes, it is.
and was this something that was not in our agreed upon instructions yesterday?
It wasn't the agreed upon instructions yesterday, but I just wanted to make sure that
It's
you
acceptable.
recognize that it was from it's the castle doctrine.
It's acceptable to the state, Your Honor.
And that's acceptable
What-
to you, Mr. Parnell?
Yes, Judge.
We're presenting two theories of justifiable use of deadly force. One theory is the theory that applies to being within a dwelling home. The other one applies to being out in the world, everywhere else. Upon further consideration, I don't know why it makes sense to give both if one is applicable. Squarely on point. I believe defense had requested both, but now having slept on it and having co-counsel point it out, I think that it kind of makes this longer than it needs to be and maybe more confusing than it already is.
That's the reason I brought it up. Mr. Parnell, what are your feelings about that?
Not really sure why it would be confusing. It's an accurate statement of the law.
But that particular section is the castle doctrine.
Right, I think
Not really
that-
not really what we have here, but
I don't think the jury should be in any scenario where they don't understand the law about her having to retreat or having no duty to retreat. I think an accurate statement of what the law is should be here.
Well, if defense wants it, I'm certainly not going to argue to take it out, but I think it makes it maybe more confusing. But we'll definitely defer to defense on this issue.
What do you want to suggest, Mr. Wiggins?
I was going to suggest allowing the jury to go to lunch, so we could maybe get back a little earlier if we let them go a little earlier.
Let's do that. So we'll start at 1 and then end, if I do 2 hours and 2 hours for your closings, then we'd end at 5?
Yeah, sure.
All right, let's bring them in, and I'll tell them that I'm going to let them go to lunch now. We'll come back at 1. I just wanted to bring you in to let you know we're going to go to lunch now, and so we'll come back at 1 o'clock. And when we come back at 1 o'clock, you will have the jury instructions in your chairs so that you can follow along with me while I'm reading. And after I give part of the instructions, then the attorneys will begin their closing arguments, and I will follow up with final instructions. And after I follow up with my final instructions, the alternate will be dismissed, and then the panel will go back and begin their deliberations. So, 11:30 till 1 o'clock. I'll see you back at 1. Have a good lunch.
You ready, please?
I need you to stay back after we do. Is there anything, any issues on the verdict? State?
None from the state, Your Honor.
Verdict form is fine.
Okay, so, I will have these printed out. I will have a copy for all 3 of you at defense table and both of you there. I'll have one for the court reporter, the 8 there, and, everyone have a good lunch. All right, we're in recess until 1. Ms. Garcia.
Also have a copy of the the verdict form.
You could just give me a minute.
Thank you, Your Honor.
Still a good number for you, or a good amount of time?
Yes, Your Honor.
Mr. Parnell? 2 hours?
Yes, that's plenty. What are we going to do about the potential sleeping juror that we
We
discussed?
need to talk about that. Okay. The juror missed technical parts of the testimony and was asleep during the DNA expert and when we had some of the digital forensic. That's what I know I saw. Counsel both stated instances where they saw that he was asleep. So I'm going to switch that juror out with an alternate. What is of concern is that one of the alternates was also sleeping during some of the technical parts of the testimony too. And that would be the alternate number 1. So what I will do is I'm going to use alternate number 2 in place of the juror who was in seat number 5. So you, okay. All right, so let's bring in the jury. Record should reflect counsel for the state are present, counsel for defense are present, as is Ms. Redlick. I'm setting a timer. I will give you both a 2-minute warning. As I told you before we left, your jury instructions are going to be in your seats, and you can follow along with me as I read these instructions to you. After I read the instructions, the state will begin their closing, followed by the defense, followed by a rebuttal for the state, and then I will conclude with the final instructions. Page number 1. Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. Next page. Statement of charges. Danielle Justine Redlick, the defendant in this case, has been accused of the crime of second-degree murder with a weapon and tampering with physical evidence. Next page. Introduction to homicide. Danielle Justine Redlick is accused of second-degree murder with a weapon in count 1. Murder in the second degree includes the lesser crime of manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Michael Redlick was killed by Danielle Justine Redlick, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the second degree, manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. Next page. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house or residence in which the defendant was at the time of the killing. Next page. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune, in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. I now instruct you on the circumstances that must be proved before Danielle Justine Redlick may be found guilty of second-degree murder or any lesser included crime. Next page. Count 1, murder, second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Michael Redlick is dead. 2, the death was caused by the criminal act of Danielle Justine Redlick. 3, there was an unlawful killing of Michael Redlick by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 3, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. Serious bodily injury means a physical condition that creates a substantial risk of death, serious personal disfigurement, or protracted loss or impairment of the function of any bodily member or organ. In order to convict of second-degree murder, it is not necessary that the state prove the defendant had an intent to cause death. Next page. Aggravation of second-degree murder by carrying, displaying, using, threatening to use, or attempting to use a weapon. If you find that Danielle Justine Redlick committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, she personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find her guilty of second-degree murder with a weapon. A weapon is defined as 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Danielle Justine Redlick committed second-degree murder, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find her guilty only of second-degree murder. Next page. Count 2, tampering with physical evidence. To prove the crime of tampering with physical evidence, the state must prove the following two elements beyond a reasonable doubt. 1, Danielle Justine Redlick knew that a criminal trial or proceeding or an investigation by a duly constituted law enforcement agency of this state was about to be instituted. 2, Danielle Justine Redlick altered, destroyed, concealed, or removed any record, document, or thing with the purpose to impair its verity or availability in the investigation or proceeding. Next page. When there are lesser included crimes. In considering the evidence, you should consider the possibility that, although the evidence may not convince you that a defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder is manslaughter. Next page. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Michael Redlick is dead. 2, Danielle Justine Redlick intentionally committed an act or acts that caused the death of Michael Redlick. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I had previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Next page. Aggravation of manslaughter by carrying, displaying, using, threatening to use, or attempting to use a weapon. If you find that Danielle Justine Redlick committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, she carried, displayed, used, threatened to use, or attempted to use a weapon, you should find her guilty of manslaughter with a weapon. A weapon is defined as 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that when used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Danielle Justine Redlick committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find her guilty only of manslaughter. Next page. Justifiable use of deadly force. It is a defense to the crimes of second-degree murder and manslaughter if the actions of Danielle Justine Redlick constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. The use of deadly force is justifiable if Danielle Justine Redlick reasonably believed that the force was necessary to prevent imminent death or great bodily harm to herself while resisting another's attempt to murder her, or any attempt to commit manslaughter, aggravated battery, or aggravated assault upon her, or any attempt to commit manslaughter, aggravated battery, or aggravated assault upon or in any dwelling house in which she was present. Danielle Justine Redlick was justified in using deadly force if she reasonably believed that such force was necessary to prevent imminent death or great bodily harm to herself, or the imminent commission of manslaughter, aggravated battery, or aggravated assault against herself. If Danielle Justine Redlick was not otherwise engaged in criminal activity and was in a place she had a right to be, then she had no duty to retreat and had the right to stand her ground. The elements of manslaughter have been previously explained to you. The elements of aggravated battery are defined as follows. 1, Michael Redlick actually and intentionally touched or struck Danielle Justine Redlick against her will. 2, Michael Redlick, in committing the battery, intentionally or knowingly caused great bodily harm to Danielle Justine Redlick. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. The elements of aggravated assault are as follows. 1. Michael Redlick intentionally and unlawfully threatened, either by word or act, to do violence to Danielle Justine Redlick. 2. At the time, Michael Redlick appeared to have the ability to carry out the threat. 3. The act of Michael Redlick created in the mind of Danielle Justine Redlick a well-founded fear that the violence was about to take place. 4. The assault was made with a fully formed, conscious intent to commit second-degree murder, manslaughter, or aggravated battery upon Danielle Justine Redlick. Next page. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Danielle Justine Redlick may be found to have been in fear. An actual fear on the part of Danielle Justine Redlick need not be shown. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. It is not necessary for the state to prove that the defendant had an intent to kill. If Danielle Justine Redlick was in a residence in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself, or the imminent commission of second-degree murder, manslaughter, aggravated battery, or aggravated assault against herself. The elements of second-degree murder, manslaughter, aggravated battery, and aggravated assault have been previously explained to you. In deciding whether Danielle Justine Redlick was justified in the use of deadly force, you must consider the circumstances by which she was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under the same circumstances, would have believed that the danger could be avoided only through the use of that force. Based upon appearances, Danielle Justine Redlick must have actually believed that the danger was real. However, the defendant had no duty to retreat if she was not otherwise engaged in criminal activity and was in a residence in which she had the right to be. However, the use of deadly force is not justified if you find that Danielle Justine Redlick used force to initially provoke the use of force against her, unless the force or threatened use of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger, other than using deadly force on Michael Redlick. If you find that Danielle Justine Redlick, who because of threats or prior difficulties with Michael Redlick, had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Michael Redlick, you may consider this fact in determining whether the actions of Danielle Justine Redlick were those of a reasonable person. If you find that at the time of the alleged second-degree murder or manslaughter, Danielle Justine Redlick knew that Michael Redlick had committed an act or acts of violence, you may consider that fact in determining whether Danielle Justine Redlick reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Danielle Justine Redlick and Michael Redlick. If, in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Danielle Justine Redlick was justified in the use of deadly force, you must find her not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Danielle Justine Redlick was not justified in the use of deadly force, you should find her guilty if all the elements of the charge have been proved. Next page. Justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder and manslaughter if the actions of Danielle Justine Redlick constituted the justifiable use of non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. Danielle Justine Redlick was justified in using non-deadly force against Michael Redlick and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against Michael Redlick's imminent use of unlawful force or the imminent commission of second-degree murder, manslaughter, aggravated battery, or aggravated assault against herself. The definitions of those crimes have been previously explained to you. In deciding whether Danielle Justine Redlick was justified in the use of non-deadly force, you must consider the circumstances by which she was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Although, as previously explained, the defendant had no duty to retreat. Based upon appearances, Danielle Justine Redlick must have actually believed that the danger was real. However, the use of non-deadly force is not justified if you find that Danielle Justine Redlick used force to initially provoke the use of force against herself, unless the force or threatened force asserted toward Danielle Justine Redlick was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger, other than using non-deadly force on Michael Redlick. If you find that Danielle Justine Redlick, who because of threats or prior difficulties with Michael Redlick, had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of Michael Redlick, you may consider this fact in determining whether the actions of Danielle Justine Redlick were those of a reasonable person. If you find that at the time of the alleged second-degree murder or manslaughter, Danielle Justine Redlick knew that Michael Redlick had committed an act or acts of violence, you may consider that fact in determining whether Danielle Justine Redlick reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Danielle Justine Redlick and Michael Redlick. If, in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Danielle Justine Redlick was justified in the use of non-deadly force, you must find her not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Danielle Justine Redlick was not justified in the use of non-deadly force, then you should find her guilty if all the elements of the charge had been proved. Next page. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has a burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Next page. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in this case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Next page. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Next page. And ladies and gentlemen, after I read this page, then the state and the defense will begin their closing arguments. So both the state and the defendant have rested their cases. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening statement and a rebuttal argument after the defense has given its closing argument. Give me just a second. Yes. Mr. Wiggins?
On May 14th, 2018, Danielle Redlick sent her husband, Michael Redlick, an email. And on January 11th, 2019, she would, in perverse and terrible ways, bring that email to life. She writes, "I just want to be happy now. I made up my mind. That is what I need to commit to. Not a person or a marriage, but my own true happiness. What a concept I know. I think some of us have this subconscious belief deep down that we don't deserve to be happy, or that we don't get to be happy until we have suffered or bled to death first. Well, I think I might be one of those people, and as logical as the previous statement is, I have suffered, even bled to death." This defendant, who sits before you, would, on that evening, take this long, dull knife, as she described it, and plunge it into Mr. Redlick's body. Mr. Redlick is bleeding. He is losing massive amounts of blood. He does not have long to live. He finds himself lying on the floor, looking up at the ceiling of the home that he once shared with Danielle and Jaden and Sawyer. With moments, minutes left in this world. This defendant told you that at some point before 10:50 that evening, that she stood over Michael. She stood over Michael with her phone in one hand and a thought in her head. She told you that she thought it was possible that Michael could be saved because she wouldn't do CPR on someone she thought was dead. And in that moment, Danielle Redlick had a choice. She had a choice to call 911 and get emergency help personnel to that residence, or she could do what she did, which was perform amateur CPR. She is standing over him with the power to help. She chooses in that moment to let Michael Redlick bleed to death. Why? Why did she let him, she believed he could be saved, die on that floor? She told you, and the state is not arguing, that Miss Redlick intended to kill Michael Redlick. She cared more about not sitting in that chair that she sits in today than saving Michael's life. She goes on in that email that she, in just these perverse ways, brings to life, and talks about how she really wanted the Romeo and Juliet story, a soulmate to trust, melt into, be there, and even die for. That's not the only time you saw this reference to Romeo and Juliet come up. You see it in her Meet Mindful account, this desire to have the Romeo and Juliet love. And if we think back to maybe our high school or English class, the story of Romeo and Juliet, those star-crossed lovers, that when Juliet sees Romeo dead, having drank the poison, she arms herself with a dagger and takes her life. 11 or so hours later, this defendant arms herself with a sharper knife, that silver knife that's in that kitchen sink, and she slits her own wrists. And you heard that it wasn't because she wanted to be with Michael in the afterlife. It wasn't because she couldn't imagine a world where she and Michael weren't walking alongside each other. She admitted to you on this witness stand, that at least in part, she slit her wrists because she didn't want to have to answer for what she had done. Now let's compare and contrast how this defendant acts when she stabs Michael and he is gushing blood into that home, to how she acts when she slit her own wrists. Because it's only when she is bleeding that she dials 911. She thinks to save herself. She told you that. She didn't want it to go this way. When she is in danger that she's inflicted on herself, she calls for help. You have heard through the course of this case the investigation that followed, the physical evidence that was found on scene, the physical evidence that was obliterated by this defendant. You heard about what Ms. Redlick was doing on her phone in the months leading up to killing her husband, what she was doing on her phone the night she killed her husband, the morning she killed her husband. You learned about Ms. Redlick's physical condition when law enforcement arrived, and her physical condition when she reported or she was taken to the ER. You learned about Michael's condition when an autopsy was performed. And you heard Danielle Redlick speak. You heard her in a 911 call. You heard her in that recorded call to Detective Ware. You heard her speak through other witnesses, the statement she gave to Terrell Tucker and Frederick Copeland. You heard her in that search warrant audio on the 18th, protesting, denying her involvement. You heard her own testimony. You had an opportunity through the course of this case to listen to Ms. Redlick and evaluate her story and her credibility. And then you heard jail calls. And you heard two sets of jail calls in this case. You heard jail calls of Ms. Redlick talking on her pen and the conversation she carries on when she thinks she's being listened to. And then you heard the conversation that Ms. Redlick engages in when she doesn't think she's going to be heard, when she thinks that she can talk freely and talk about things that you folks will never hear. Why did the state present all this evidence? Why did we present the evidence of Michael and Danielle's relationship, this relationship of two very imperfect people? And all the physical evidence and the cell phones and the records and stuff. It was all presented for one reason. To prove the elements of this offense beyond a reasonable doubt. We talked about the elements in jury instructions, or jury selection rather. We talked about the BLT. This is the BLT. This is the bacon, the lettuce, and the tomato of this case. This charge, the tampering charge, and the lesser included manslaughter charge. All of that evidence is directed at these elements and these elements alone. And it's to these elements that you apply the burden and determine whether the state of Florida has met its burden of proving each and every one of those elements. So let's talk a little bit about second-degree murder and the elements of second-degree murder. Element number one is not in dispute, okay? Element number two is the act of Ms. Redlick jabbing that knife into Mr. Redlick's shoulder. Now, that's a criminal act unless, of course, it's justified. That is the criminal act, and there is, as Ms. Redlick said, a justification for it that you're going to have to consider, and you've been instructed on these decisions, in these instructions. And then you have element three. Element three is kind of, I have to imagine for a group of jurors who's never seen the definition of second-degree murder, probably very strange looking. The state of Florida has to prove that there was an unlawful killing, so an unjustified killing, of Michael Redlick by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Fortunately, you get some definitions of what a depraved mind is and what an indifference to human life is, and that's what you see down here, these three bullet points. to help you understand that kind of strange formulation in element 3. So let's talk a little bit about the evidence that you have to each one of these aspects that the state has to prove in element 3. We have a person of ordinary judgment would know it is reasonably certain to kill or do serious bodily injury. So in this particular case, the evidence is overwhelming from the defendant's testimony. The size of this knife, and the testimony of the medical examiner, that the choice to take a knife like this and plunge it into someone's body where veins, arteries, organs are all located, a person of ordinary judgment would know that is likely to do, at the very least, serious bodily injury. You know, you take a big old knife and you jam it into someone, serious bodily injury is going to occur. And we have a definition of serious bodily injury. Serious bodily injury means a condition, physical condition that creates a substantial risk of death, serious personal disfigurement, or protracted loss or impairment of the function of any bodily member or organ. So in this case, you have testimony that each one of the knife wounds to Mr. Redlick would have caused scarring. Scarring to his face, scarring to his shoulder, scarring to his side. You have that disfigurement. Then you also have this very clear evidence of protracted loss or impairment of the function of any bodily member or organ. Specifically, you have the testimony that relates to the fact that that knife travels through into the shoulder, through the skin tissue, hits a vein, goes through a pectoral muscle, and then enters into the chest cavity. And the medical examiner talked about how devastating that is going to be for a person, and then continues further and actually pierces the lung. You saw the hole in Michael's lung. That is, without any serious dispute, the type of injury that is going to cause protracted loss or impairment in the function of any bodily member or organ. That is the state's evidence as it relates to the serious bodily injury portion of that instruction. The state is not saying, because, throughout this case, Ms. Redlick has made statements about how she didn't think that, she was surprised that Michael died. And I think it's a dangerous game to put any stock in things Ms. Redlick says, but it's not entirely unreasonable that you stab someone in the shoulder and you don't think that you're going to kill them. And the state probably agrees with that. That when she stabs him there, that everything that results was a bit of a surprise at the end of the day. But the state doesn't have to prove that she intended to kill him, or even that she knew that the location of that stab wound would bring about death. But an ordinary person knows, big old knife into someone's body, deep enough to hit their lung, that element and that aspect of that element has been proven. It is done from ill will, spite, hatred, evil intent. And that was where a lot of this case was sort of played out, is showing you this relationship. Ms. Redlick talked to you about the relationship, but the state showed you hard evidence in the form of these emails, these journal entries, and that jail call on that alternate PIN number where she talks about Mr. Redlick and how terrible he had been for 5 to 6 years and how he had just been awful to her and sophomoric and nasty. And you see in that email on the 14th of December, he's a lying, rotten son of a bitch. This is how Miss Redlick felt about Mr. Redlick. And this is how she felt when she plunged that knife into his shoulder. She certainly had ill will. I submit to you that she had hatred, but I don't have to prove each and every one of them. I only have to prove one beyond a reasonable doubt. There's ill will. I submit evidence of hatred. I submit evidence of spite. And certainly, The decision itself evidences evil intent. This was not done with anything but an evil intent. And so, as it relates to that aspect of what I have to prove related to element 3, the state has proven beyond a reasonable doubt that aspect. Now, the third portion is of such a nature that the act itself indicates an indifference to human life. And in many ways, everything I just said sort of goes to this, is that the choice to take this big knife and plunge it that deep and just see what happens is indifference. Because once again, inside your body are all the things that keep you alive. And when you start jabbing sharp objects into the areas of your body that keep you upright, you are telling that person and you are telling the world that you are indifferent to the consequences. But there's more. There is what Miss Redlick told you she did. She told you from her own mouth that she believed that he could be saved. She believed he was not dead. And she let him die. If she was right, she let him die. And if that is not indifference, if that is not putting your life and your interests ahead of the man laying on that floor, then the state of Florida does not know what else is. And the most important, not the most important, but the thing that you must sort of understand is that the state does not have to prove that she intended to kill him. They cannot prove that. It does not have the evidence that this was an intentional killing. It doesn't have that evidence, it hasn't offered that evidence, and it wasn't required to provide that evidence. So that's second-degree murder. And we talked about, in jury selection, all the questions that come up in the course of a trial, and all of the questions that come up in the minds of a juror that may seem extraordinarily important. And that if those questions don't relate to the elements, they are not a basis for reasonable doubt. But that doesn't mean that you might not be sitting there with certain questions about why this happened. And the state of Florida does not have to prove why. The state of Florida cannot tell you definitively why on this night Danielle Redlick decided to do what she did. It doesn't have to. And I will not get up before you and tell you I know. I will not get up before you and speculate and say, oh, this is why this happened. But what the state of Florida has done throughout the course of this case is given you context to understand this defendant, this relationship, and what was going on in the months, the years, weeks, and days before she murdered Michael Redlick. Defense in their opening statement talks about how Michael had this power dynamic. And the state agrees. There was a power dynamic in this relationship. Michael Redlick was older. He had the job, a prestigious job, a string of prestigious jobs. He had the money. He had the connections. He had the power within the relationship. Danielle told you, she told you, you don't have to rely on me, these words came out of her mouth, that when she filed for divorce, Michael weaponized this, weaponized it against her, and threatened her that she'd be out on the street and she'd be destitute. You saw the divorce petition, how she had sought sole and exclusive access and rights to that home. What you learned is that on December 5th, 2018, she begins to make a series of decisions engaging in this activity related to meat mindful and talking to other men that Michael Redlick will eventually discover. And the state of Florida offered the email on the 14th because it submits to you that it provides context for who she is as a person and how she was acting within this relationship. And this is in evidence of States 58. So while Danielle Redlick has joined a dating app, and you saw this wasn't just a thing where she joined and then never logged back in. Literally, I won't say literally because I may be wrong, but go through that timeline and you can see it sure seems that every single day she's on that application matching and viewing and matching and viewing. And she's apparently connected with this Caesar individual that while she's doing that activity, she dives into Mr. Redlick's email and she finds this email from 2012. She digs it up, she forwards it over or sends it to him, CCs herself, and calls him a lying, rotten son of a bitch. I'm done with you, Mike. We should talk about ending this. I'm ready. You're the most untrustworthy person I've ever known. And I have every right not to be with that person. While she is herself trying to meet men outside the marriage, while she is herself listed as separated on that app. Why does this matter? Well, the state submits to you that it establishes some context for what comes next. Because on the 10th of January, 2019, she's caught. And on the 10th of January, 2019, Danielle Redlick has lost the one thing that she can hold over Michael Redlick. That until that point in time, he was the cheater. He was the one who had been unfaithful. And now she was. So the one thing that she drags out and uses to call him a lying, rotten son of a bitch, she doesn't have anymore. And she knows the divorce is going to be more difficult and everything that's going to come with this. And you heard that Michael is sarcastic and sometimes sharp with his tongue. And this is what's going on leading up to and on the 10th and onto the 11th. And the state of Florida will not get before you and justify how Michael Redlick acted on the 10th. Maybe some of us can understand it, but I'm not going to attempt to make it okay or say, oh, this is why it's understandable. He found out that his wife was having, talking to other men, and he reacted, and he reacted in quite a upset way. Is that understandable? Is it not? That's for you to decide. But not really, because unless it relates to the elements. But in any event, you know that he is upset. He is upset at this point, and that's what's going on as we lead into the 11th. But why? Why on that night does it happen? I can't tell you. I can't tell you. I don't have to tell you. The state doesn't have to tell you why. It only has to prove those elements. But all of this context, the understanding of this relationship, the understanding of who she is, helps make some sense out of the senseless. So let's jump for just a moment and talk about tampering. We will see in just a moment whether defense makes an argument that she's not guilty of tampering. It is going to be a tough argument to make because if we look at the elements of tampering, it is as clear as it could be that she engaged in evidence tampering. Her husband is dead on the floor. She tells you she knows that in the late 10 o'clock, 11 o'clock hour. Sawyer and Jaden are eventually coming home, and she knows that at some point, the police are coming and an investigation is happening. There is no doubt that that's going to happen. She knows it's going to happen, because and she tells you that she knows it's going to happen, not just by any words, but her actions. She knows an investigation is forthcoming, and that's why she starts to do everything that she does. She is not cleaning the house because she's worried about house guests that are going to be coming over in 48 hours. She is cleaning the house to make this scene look like something it's not. And that's why what she says when she first picks up the phone to 911 is so telling. It was a heart attack or something. I think my husband's dead. She is endeavoring in an attempt from the start, when she knows that the police are going to come knocking and this investigation is inevitable, to change that scene. To make this be something that doesn't land her where she sits today. Not only does she clean up the scene, and you heard from Stuart James, I'm not going to go into his testimony in detail. All of you were paying attention throughout the course of this case. You heard how basically from corner to corner of the scene, she altered it with mops and towels and water and what appears from the testimony of the officers that responded, cleaning solution. The trash that's got blood on it. Everything she did to change that scene so it could be something it's not. But there's more. She decides in those moments, she tells you early on, she doesn't give a very clear explanation for why, that she takes out her phone after she's murdered Michael Redlick and she begins deleting text messages.
Objection, improper argument. Judge, can we approach?
Yes. Wiggins.
So in addition,
Hold on just a second. When I have bench conferences, I need you all to keep it down. The excessive talking and the loud noise is very disruptive and distractive. If you can't do that, kindly leave. Mr. Wiggins.
so in addition to just obliterating all of that blood evidence inside the house and doing quite a thorough job in the kitchen, she begins to delete text messages. And that continues to tell you what this defendant is doing and what she is guilty of. And how everything that's happened since the moment that she's put that knife inside of Michael is to avoid responsibility for her actions. She can't explain why she deletes those messages. But it certainly makes her guilty of tampering under the law. So then we'll talk about manslaughter. Manslaughter is a charge that you only consider once you've decided as a group. All 6 of you look at that second-degree murder charge. If you unanimously decide the state has not proven manslaughter beyond a reasonable doubt, that is when, second-degree murder beyond a reasonable doubt, that is when you consider the lesser included. So you don't just sort of jump down to it. You start with the highest, and then you go to the lesser if the state hasn't proven the higher charge. And the only lesser included offense in this case, it is manslaughter. So manslaughter are, in many ways, more straightforward than second-degree murder. Michael Redlick is dead, no dispute there. Danielle Justine Redlick intentionally committed an act or acts that caused the death of Michael Redlick. So you commit an act, intentionally so, and someone dies. You have this language, every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. And you cannot be guilty of manslaughter by committing a merely negligent act. So for example, you're driving home, you lose control of your vehicle, and you hit another vehicle and someone dies. You did not intend to do that. You were involved in an act that killed someone, but you didn't commit an intentional act. You may have been negligent in the way that you're driving. You might have been looking at your phone. You might have not ever changed your tires. You might have made a series of really, kind of questionable decisions, but you didn't do anything intentional. That's an example of a death that wouldn't make you guilty of manslaughter. Here's an example of a death that would make you guilty of manslaughter. You're in a bar fight with some guy that you just met. You'd spilled a drink on your shoe. And you look up and you punch him. He falls. He hits the bar, cracks his head, and dies. You never intended to kill him. You didn't really know this guy, and all he did was spill a drink on your shoe. You didn't know him from Adam, but now he's dead. You're guilty of manslaughter. The principal difference between manslaughter, or the big difference as you see between manslaughter and second-degree murder, is that second-degree murder accounts for a murder that occurs when someone has had the opportunity to develop some sort of animus, some sort of enmity towards another human being. Precisely as Ms. Redlick had. She did not commit a manslaughter. She committed a second-degree murder with a weapon. Now, we'll talk about that aspect of this decision you have to make at this point. So, you find her guilty of second-degree murder or manslaughter. You would check off this particular form. Here, or here. If you find her guilty of second-degree murder or manslaughter, you have to address this form, this special finding form. Because you need to make and show that you have all determined beyond a reasonable doubt that during the commission of the said offense, the defendant did carry, display, use, threaten to use, or attempt to use a weapon. You have to make that separate decision. In this particular case, that is not going to be a hard decision to make. Ms. Redlick admitted that she committed this murder with a weapon. So if she's guilty of either one of the homicide offenses, she's clearly, you clearly check did. That's the sort of process. There's not really going to be a dispute. That should be not a hard decision for you to make because she did use that big, long, dull knife that she told you she did. So, let's continue to talk about the jury instructions. We talked about reasonable doubt in jury selection. We talked about what that burden is. And we all agreed, or you all agreed, that you would hold the state of Florida to this burden. Not a higher burden, not a lower burden, not any other burden than this burden. To be beyond a reasonable doubt. So once again, you may have doubts at the end of this process. You are allowed to possess doubts. Provided those doubts are not reasonable doubts, you may possess those doubts, and you may check the box finding her guilty, and the box finding her guilty. The state of Florida submits to you folks that it has proven this case to the burden that is required to prove. Okay, now we move to weighing the evidence, and this is when the rubber really meets the road for Ms. Redlick. The state of Florida submits to you that in this particular case, there are two witnesses that there is much of any sort of, I think, credibility determination that needs to be made in any large degree. Now, that's my assessment. My assessment doesn't matter. It's your assessment of credibility as to each witness. But my assessment is that the two witnesses who have the most sort of credibility or a credibility assessment that you need to engage in are Jaden Redlick and Danielle Redlick, mother and daughter. Every other witness you heard from was sort of a third-party witness, a law enforcement officer, an expert. You had some folks who were friends. Their testimony obviously isn't as meaningful or as weighty in the state's estimation than Jaden and Danielle's. So, we look at Terrell and Tucker. There is no motivation for Terrell and Tucker to lie about the fact that this defendant told her that Michael was saying Sam Katie on multiple occasions, once as he stood outside that door, for example. Jaden, we apply this set of rules for assessing witness testimony. Did she seem to have an opportunity to see and know the things she testified to? State submits to you that she did. Did she seem to have an accurate memory? Was she honest and straightforward? These are the things that you have to ask with each witness, Jaden and everyone else. Did her testimony agree with the other testimony and evidence? And as you go through each one of those, I would argue that she comes out on the side of a credible witness. She told you that she acknowledged her relationship with her mom is toxic. That her mom and dad's relationship were similarly toxic. and tumultuous. And she was asked, who is the source of that toxicity? Who was the source of issues within the home? And it did not appear that it gave her any sort of joy or happiness to say it was Danielle. The person who she lived, the person who gave birth to her mother, the person who killed her father. She told you that her father was trying to make things work when he moved back in. That despite all the trials and tribulations, that in this moment in time, he was trying to make things better. He's given her flowers, trying to improve this relationship. She told you that when she left on that day, her father's car was not covered in eggs. She told you that her father was a calm, sarcastic, funny drunk. State of Florida would submit to you that most significantly, she told you that there was never an occasion where in 2015 or at any time where she was brought to a hospital with her brother and father and mother to have her treated for an injury. She told you that never happened. And that if it did happen, she would have remembered it happening. Let me get to Danielle Redlick's credibility. At the end of the day, this case is in some large measure about her credibility. She has taken the stand, she has put her credibility at issue, and she is to be evaluated like any other person who came before you. She gets no special dispensation because she was the defendant. She is a witness like every other witness. And what you heard is that every single statement that came out of her mouth until she sat in that chair, until she had to look you folks in the eye, was a denial of responsibility. The state of Florida submits to you that her testimony before you over the course of a day and a half was just one more attempt to avoid responsibility for her actions, to avoid not being held responsible for the murder she knew she committed as she stood over Michael with the power to call 911 in the decision not to. So let's examine her credibility by looking at the jury instructions. Did she seem to have an accurate memory? Well, let's look at an example. She can recall with great specificity, incidents that occurred 10, 15 years ago related to things that make Michael Redlick look bad. But when she's asked, well, what did you do with the knife you used to murder your husband after you killed him, she can't answer you. She can't tell you. She could provide no explanation, no recollection of what she did with that knife. Because it's not useful for her to have one. She can't come up with one that's good for her because the only explanation is one that continues to incriminate her. Because that knife you saw is set where? It is set in a pool where a pool of blood once was. You heard from the testimony of a blood spatter expert that there was that significant satellite spatter from all the blood that was right there. And it had been thoroughly cleaned. And right where it had thoroughly been cleaned, that knife is sitting. That explanation doesn't serve her interests, and so she doesn't provide it to you. Does she have an interest in how this case is decided? She has as large of an interest as a person can have. There is no larger very difficult to assess that because everything she did to alter, change, and destroy the scene. But if you really focus in on the physical evidence that we can still make inferences from and determinations from, the answer is no. Her versions of events do not match the physical evidence. And then we get to the doozy, the whopper of the point. Did the witness at some other time make a statement that is inconsistent with what he or she said in court? On cross-examination, that defendant who sits before you admits that she had 11 hours to come up with her story when she called 911, and she lies and lies and lies to the dispatcher. Not only does she just sort of tell a simple lie, she elaborates, she crafts, she acknowledges that she comes up with details to fill in her lie. Michael grabbed the knife. He made a motion towards himself. Those things never happened, and those words just flow out of her mouth. And Danielle Redlick admitted to you on the witness stand under oath that not only will she lie when it serves her interests. Did the witness have some interest in how the case should be decided? She will lie when it serves her interests. She will clearly lie when she thinks it will keep her out of that chair. She lies to Detective Ware 24 hours later, because if we want to go with this, she was panicked, sort of explanation, excuse for why she comes up with this elaborate and specific lie, she's well over 24 hours later when she sits in front of Terrell and Tucker and she gives this specific beat-by-beat story where she is lying and lying and lying. She talks to Frederick Copeland, the mental health tech. This guy isn't in law enforcement. He's no one. And she lies to him. She looks him in the face and she lies. And she lies to her daughter. You heard in that jail call, the second jail call you heard, where Jaden talks about, you lied to me, Mom. And Danielle acknowledges, yeah, I had to lie. I thought I was going to get arrested. She didn't, maybe she did in some way lie because the truth is both incriminating and just too terrible to tell her daughter. I'll grant Ms. Redlick that. But in that jail call, she also reveals another motivation, is that she lies because she doesn't want to get caught. She knows that this is coming. The most significant lie the state of Florida submits to you that Danielle Redlick told in the course of all of the statements and all of the lies is this lie she tells to Detective Ware on that phone call on January 13th, 2019. Detective Ware is giving her general information about sort of the situation and funeral arrangements, and Danielle is probing her for, it would seem to me, in the hopes that maybe this is not going to be further investigated. And in the course of that conversation, Danielle says that, I'm willing to talk. I'm willing to tell you what happened. But I already told the dispatcher what happened. In that moment, she is actively deceiving Detective Ware. She knows that she had lied to the dispatcher. And she cites back to that lie. She says, that lie, she knows is a lie, is the truth. I already told. You've already heard the truth. Just go listen to the 911 call. And then, even more significantly, she does something that shows you the level of deceit that this defendant will engage in to save her own interests. She goes, I've told the people in here what happened, and I'm sure that you can get access to the records. And she invites Detective Ware to follow up and speak to the people that she's lied to. That is calculated and purposeful deceit. Why would she do that if she wasn't trying to deceive everyone? That is not the actions of someone who is making decisions out of panic. That is the actions of someone who is calculating a way out of responsibility. I will lie, and then I will tell the detective to come talk to the people I lied to. You were all selected because you indicated that you would not check your common sense at the door. This defendant has lied and lied and lied and got caught, and now comes before you and says, I'm telling the truth. Today's the day. If you heard her when she was being pressed, she said, well, I didn't think that it was time for me to tell my story. Well, it wasn't ever time to lie. There was no reason to actively and connivingly lie the way that she did, except that she can't face the truth, because the truth makes her guilty. And then you take lie after lie after lie, and deceit after deceit after deceit, and you take that and you marry it with everything she did afterwards. And you see over and over and over again the lengths that this defendant will go to avoid having to answer for what she did. This defendant got on the ground, picked up Michael's 240-pound torso, took his shirt off, and threw it in that pile of towels. She admitted to you that she moves his arm attached to his dead body to clean under. She moved the arm under that is attached to his lifeless body, lifeless for hours, so she can clean up just a little bit better. So somehow, some way, she won't be looking you in the eyes like she is today.
Minutes.
We look at this email and we realize how much she's brought this to life. And how throughout this email, she returns to this theme of a sharp tongue. And although my words may be cutting, they are only sounds, a dull knife, compared to your sharp, disloyal, deceiving, phony, and never-ending selfish knife that you continue to twist in my back as if it's a sport at this point. This theme of knives continues in this email that she makes real. I notice whenever I confront or attempt to process, to work through the cuts your knives wound me with, you have a hard time and trouble admitting the true nature of just how sharp and dangerous their edges are. They are nonetheless weapons, and you are always claiming the right to hurt me with them. I mean, how do you love a man who will, because you are acting in agony over the aftermath of his cutting and hurtful actions to begin with? It is clear that to Danielle Redlick, Michael Redlick's words and actions cut like a knife. Well, on the 11th, she cuts him with that knife. And she does everything that she can from that point forward. From the moment that she realizes that she has killed this man to avoid answering for what she has done. Today is the day that Danielle Redlick answers for her crimes. Today is the day that you return a verdict that speaks to the truth of what happened to Michael Redlick. Today's the day that she's found guilty as charged for what she did. Thank you.
Mr. Parnell.
We're number 296.
January 12th, 2019, 7:22 in the morning. As Redlick wakes up, it's a horror scene. It's like you heard Mr. Wiggins last week. Something out of a horror movie. It's not one that she asked for. It's not one that she was prepared to deal with. That's not the beginning of this story. The beginning of this story is much earlier. To understand why this story ends the way it does, you need to understand how it begins and how it continues throughout the relationship until we get to where we are right now. 1990s, Cleveland, Ohio, Michael Redlick starts pursuing his former stepdaughter, Danielle Redlick. They begin a relationship. Relationship continues. It goes from a parent to a partner match, but not really. That's not what you heard about. That's not what you saw. These aren't partners. You heard about controlling. You heard Mr. Wiggins just talk about it, the power dynamic in this relationship. Authority. That continued during the entire time that they were married. I heard about how Michael would fly her out to Tennessee, how he would get jobs for her, things like that. She's a possession, bought and paid for. His. Nobody else's. His. You heard testimony during this trial about how Michael's insecurities about his job, about his body, relationship, would lead to fights, would lead to physical aggression, violence against his wife, Danielle, in their home and in other areas. You heard how sometimes she would fight back. Mostly she'd normalize it. She'd get flowery words, an apology, a hope that it would be better. It's not. Same cycle continues. You heard those examples of being hit, being pinned down, trapped, defenseless, being choked. The look in his eyes as he would attack her, as he would attack his property, because of his ego, because of his insecurities. His insecurities that would repeatedly lead to violence against his wife. The purpose of this is not to say he's a bad guy and that he had it coming. The purpose of this, the purpose of the testimony about the prior events, prior violence, aggression, rage, is so that you understand what she is dealing with on January 11th of 2019. As she is trapped, as she is pinned down, as she is smothered, as she is thinking, I'm going to die here, in her own kitchen of her own home, at the hands of her own husband. That's why that context is important. And that's why you heard it during this trial. The question before you: has the state convinced you beyond a reasonable doubt that Ms. Redlick stabbed her husband out of ill will, hatred, malice, evil intent? They've taken away every reasonable doubt. She was doing it to protect herself, to defend herself, because she can't get away. The law does not require her to get away, to retreat, but she couldn't. The only option she had in that kitchen was to take action. Mr. Wiggins says so that she's not in this chair, so she can escape that kitchen, is why she takes action. You heard repeatedly from the state that they cannot tell you why she killed her husband, why she stabbed him. We can, and we'll use the state's evidence to do it. We heard on testimony from his friends, from Jaden. Michael Redlick is a man who, during the relationship, he gets caught cheating. January of 2018. Gets kicked out of the house. His wife files for divorce. But he wants to make it work. He wants to fix the family. He wants to get back together, try and reignite the relationship, try and make it back home. And he does. Moves in the fall. Things are going okay. You hear Jaden on the stand. Things are going well. Christmas, holidays, going fine. Nice steak dinner in early January. January 10th, 2019, he finds something. Finds that his wife, who he's been trying to reconcile with, trying to get back together with, has been talking to another man behind his back. How can this happen? How can she betray him while he's trying so hard to make this work? How can she do this to him in his mind? So he demands answers. He's calling. She's not answering.
12:50, not answered. January 10th, 12:50, 40 seconds. January 10th, 12:52, not answered. January 10th, 12:56, not answered. She's ignoring him. She betrayed him. She's talking to another man, but she won't talk to him. Is he okay with this? Let's listen.
You must have really loved doing this to me. Sleeping with me, and then texting them immediately, calling them, whatever you were doing, however you were communicating. Laughing behind my back. Yeah, Mike, you don't even know I'm really fucking you now. You must have really enjoyed that, didn't you? And don't tell me anymore, oh, you remember who Dan was. You are who Dan is. Your record is what your record says you are. You are Dan, and that's who you've always been. A person that would do something like that. You must have really gotten a great laugh out of it the other night. Oh, I think I'm going to start studying jiu-jitsu. Yeah, right. You must have just been howling inside through all this. The hurt, taking reveling in what you were doing to me. I'm going to take jiu-jitsu classes. I'm going home. I'd really appreciate it if you check into a hotel.
We heard from Jaden. What happens the rest of that day? Dad comes home that night. He's very distant, not super talkative. He seemed like he was really upset about something. He was cold. Mom looks nervous. He starts drinking that night. He keeps drinking that night. Things are so tense between Mom and Dad. They're arguing. Dad was very upset. So upset, as you heard from Jaden, that she has to intervene. She has to get between them. She has to take his liquor bottle, throw it away out in the dumpster outside. Those are her words. She's never seen her dad this upset before. January 10th, 2019. January 10th, 2019, 7:38 p.m. Saw your text, Danielle. Mom, they're yelling so much. Please help me. Who's they? Jaden? Michael. Please help me. He's drunk. They're screaming curse words. It's between Danielle and Jaden. 8:20 p.m., January 10th, 2019. Stay in your room. Do not engage. He's in my room. They leave. You need to get out of here. He's being violent. 8:23 p.m. I love you so much, Mom. Are you okay? Her to testify. They get out of the house. Danielle drives Jaden away. She goes to stay at a friend's house. After this, I flushed a lot of it down the toilet. Don't be mad at me. She's gone for the night, but what's Miss Redlick doing that same night, January 10th, 2019? Is he asleep yet? I'll check from Sawyer to Danielle. He's passed out, but be quiet. Oh, wait a bit, please wind down. Tell him to go to bed. Turn off the lights around the house. Okay. I just dropped off Jade at a friend's house. Sitting in Alabama Avenue in a vehicle. Waiting to come home. Waiting to be safe to sneak into her own home. Says I'm gonna do it. I'm gonna turn the lights off. Okay. The TV's on. I'm gonna keep it on, just in case. Okay. You shouldn't sleep by me, in case he gets up. I'll go upstairs when I come in and be very, very quiet. Sorry about this mess. Her son, 12-year-old son, texting her how to sneak into the home to avoid her husband. I'll do the lights and wind down. Okay, can't turn them off. Can't turn off the front light because he's there snoring. They'll notice. All right, I'll wait a bit. Can you open the garage so I can come in that way? I'll try. He might notice. And he does it. Opens the garage. The dog barks. He's up, all caps. He heard, all caps. And he falls back asleep. It's okay, he's falling back asleep. And then she sneaks back in to her own home. That's the scene the night before Michael Redlick dies. The next morning. Line 22, from Mike Mobile to Danielle's phone. 7 o'clock in the morning, not answered. Where are they? 7 o'clock. They're both home at the Temple Drive address. Still hiding out from her husband. heard from UCF worker Maria Molina. Michael was at work. Leaves a little bit early. She sees him leaving work around 3 o'clock or so. Out at UCF. We know that's not true. We know where he is at from 1:13 until 2:30 at home in Winter Park. Between 4:30 and 5. Video collected by Detective Ware. Michael Redlick, 4:37 p.m. Another vodka bottle. We heard from Jaden. She's home with him that afternoon. This is Friday, January 11th. He's apologizing profusely. He's sorry that she had to see him that way the night before. She wouldn't talk to him. She didn't say a word to him that day. Last thing she said was the argument they had had the night before she left the home, before Danielle had to sneak back in. We know Michael takes Sawyer to the football game. Miss Redlick shows up later. We heard from Marcia Inglis, friend at the game. She says Miss Redlick is upset. She's irritated. There's something on her mind. She says it's been a strange evening. We hear from Pete Dybel, another friend, another coach on the team. Doesn't see Michael and Danielle interact at all at the game. Says that Danielle is quiet. He talks to Michael afterwards. Michael's distracted. He's ready to get out of there. We know that night, Jaden is left around 5:30 before the football game to go stay with a friend. We know that at the football game, Sawyer leaves with the Inglis's, goes to stay with a friend. We go home after the game. .37. Michael calls. No answer. Danielle's phone. Both in Winter Park. Here's the home. Heard in her testimony that she had gone to McDonald's. Again, she doesn't answer him. .46. Ms. Redlick. President McDonald's. And then she goes home. What is the difference between January 10th and January 11th of 2019? The difference is who else is in the home. The difference is the children getting involved. The difference is Ms. Redlick being able to get out. We heard about the drinking. We saw him buying more liquor. We heard from the medical examiner during the autopsy, 0.09 blood alcohol content for Michael. We heard with the emergency room doctor for Ms. Redlick. She had no alcohol in her system. This is all undisputed evidence. Most of it comes during the state's case in chief. All of it comes from evidence that was obtained by law enforcement. The text messages that I just showed, you heard James Montgomery mention those came from the extraction report, the same thing as the rest of the text, the rest of the emails, the call log, the web history report, same document, that 40,000-page document. The ABC video, you heard that came from Detective Ware, was collected by Detective Ware. You don't need to take Ms. Redlick's word for what led up to this. You don't need to take my word for it. The state has proven how we got to the point where we are. The state has proven the case for Michael Redlick is the aggressor on January 11th. They've proven the case that there's a reason to be angry. He's found out his wife talking to another man, betraying him. Found out that he is fueling that betrayal, that anger, with alcohol. Heard how that night went on the 10th. The byproduct of that night on the 10th. And we know that continues into the 11th. But that's not the case the state is making. The state is making the case that Ms. Redlick killed her husband out of ill will, spite, hatred. What evidence do they have for this? She didn't stab him to protect herself. She stabbed him because she hated him. Because she wanted a life without Michael. His life was happier without him. Because divorce is hard, but apparently murder is easier. This is the state's argument here. There's no theory, there's no evidence about how the altercation happens. It's guesswork, as he said. But you don't have to take those words for it. You saw this evidence presented today, presented over these last 2 weeks to show what happened. So the evidence that the state has pointing towards hatred, pointing towards ill will and the elements for depraved mind. You're a lying, rotten son of a bitch. Nice way to talk about our daughter. I'm done with you, Mike. We should talk. We should talk about ending this. I'm ready. May of 2018, same email that the state has referenced repeatedly. Mr. Wiggins spoke about the knife imagery, the cutting, the stabbing contained in these writings. Talked about Romeo and Juliet. He argues that Ms. Redlick on May 14, 2018 is calling her shot. That in this email, she's foreshadowing that she's going to kill him with a knife. Does that make sense? Do we look at this email, look at what happened in January of 2019, and believe that these things are related? Believe that this is somehow a prediction of how this relationship's going to end? And if you really do have feelings for that woman, I guess now is the time. I'm still hurt, and it cuts, but I have the ability to move on too. So who knows from here? I guess we need to get it together as best we can. This reads more like a suicide note, if anything. She's referencing the pain that he inflicts on her, talking about nobody being happy unless they bleed out. Is this aggressive? Is there anything in this email indicating she's going to attack him? Is her weapon a knife or is it a pin? Is it a computer screen? June 16th, 2022 is apparently the day that the state of Florida discovers a metaphor. That's what's in the email. She's hurt. Feels like a knife wound that he's twisting in her back. That's it. It's not a prediction for a murder 7 months later. The state introduced evidence of pages and pages from the Meet Mindful dating website, indicating earlier on in the case that Ms. Redlick was using the site, particularly on the day that her husband died, but for weeks, a little bit over a month leading up to that. These will go back with you. You can read through them. The conversations that we have. I'm not going to read through everything, but you can look at this in the back if you want to. About hiking, about keeping up Christmas decorations. There's nothing in there about getting rid of a husband. There's nothing in there about running off together. There's nothing in there indicating some sort of plan. User records. You're not seeing any messages being sent. Just viewed a conversation. Received a message Sunday, January 13th, while she's in the Baker Act facility. January 8th was the last message she received prior to that. The last message that she sent prior to that, 8:45 a.m., January 8th. This isn't evidence of what's going on January 10th and January 11th. The state has argued that Ms. Redlick is so upset about the cheating, about the relationship, that she decides she's going to kill him on January 11th. When did she find out that he was cheating? January of 2018. When was the divorce petition? March of 2018. When did Michael Redlick find out that Danielle Redlick was talking to another man? January 10th, 2019. The state is arguing that these emails are evidence of her ill will, hatred, the rationale she's using, what motivates her to stab him on January 11th, 2019. Doesn't it make sense that him finding her messages 36 hours before he dies is more of a motivator? Are we arguing that 6 months before, a year before, is leading her to stab him? Does it make sense? Because we just went through the entire case of their evidence against Michael Redlick. His motive, his reason for being angry, his reason for getting drunk, attacking her. Does that make more sense than the idea that because the divorce didn't take, she's going to move on to the next step and stab him to death? She asked her that on the stand. You wanted him gone. You'd be happier with him gone, happier with him out of the picture. She says, no. That's not ever going to be anything because he's always going to be in my life because he's my kid's father. Put the divorce paperwork into evidence today, arguing apparently that finances were a reason for this, arguing that she wanted the house, she wanted the money. Does stabbing your husband accomplish those goals? You heard Ms. Redlick testify on the stand that part of the reason why he moved back in the fall of 2018 was because of financial issues, because he didn't have a place to stay, so he's back in the home. Does that jive with the argument that she's trying to do something for financial reasons? No, that makes no sense. It's illogical. A neighbor across the street testified that he had seen Michael and Danielle arguing. Didn't say when, said it happened a few times. I asked, was that on the 10th? Was that on the 11th? No. Okay. How are we going from that to murder, to a dead body, to a person stabbing someone to death with hatred in their heart. Your job in this trial is not to connect dots for the state attorney. Your job is to analyze and review the evidence, the testimony, everything put in front of you, and determine if they have proven their case to you beyond a reasonable doubt. Not to do their job for them. So what did happen that night? We pretty much know when and where. We know approximately what time. At the end of the day, the only testimony is from Ms. Redlick about what happened. You heard her on the stand for about 7 hours describing what led up to January 11th. You heard her talking for probably 2 of those hours about the events of January 11th, several hours, January 10th. You heard her go through all that. You saw enough of her to make your own determinations about her credibility. Is she answering questions? Is she being elusive, being defensive, being evasive when asked questions? Is she thinking about the question before she answers? Does she seem credible? Does she seem truthful? This is for you guys. You don't have to listen to the state attorney say that because she had given different stories, because she had said different things when it happened on January 10th, after finding her husband's body there, after going into the mental health facility, that those statements are inconsistent with what she said. Of course they are. It's not a good thing. People process trauma differently. But you got to see her on the stand with your own eyes, with your own ears. And part of your job is to weigh her testimony. Did she seem like she was lying, exaggerating things? If she's making up stories about physical abuse, she's not talking about a ton of times that he almost killed her, he threw her off a bridge, or beat her half to death, or stories that you might make up if you're going to lie about something. She seemed to downplay a lot of things. When the state attorney cross-examined her on things, she would be conceding things that he would say several times. If you say so, I trust you, okay. Are the responses to his questions? Being an extremely aggressive cross-examination. You saw her reaction. So we know that Michael was angry. We know that he was drinking. 109 in his system. Enough to be aggravated, enough to be really pissed off, not enough to be falling down drunk, not enough to be passing out at that point. You know she stabs him one time in the shoulder, right here. You know that he walks around a little bit. We know he bleeds a lot. We know he comes to rest in the living room. We know he didn't walk around very long. The evidence doesn't support that. What's he doing in that time frame? He's not leaving the house. He's not calling 911. He's not calling anybody else. We know there's eggs. The state attorney brought up eggs several times during their cross-examination, during the opening statements. We've seen a lot of photographs of eggs. These are our vehicles in front of the home on January 12th. Mr. Redlick's car here at the front door. Ms. Redlick's car on the side. Eggs on the ground. Something on the window. Eggs inside the vehicle. Based on where these cars are found and where the egg evidence is, as you heard on cross-examination, Mr. Wiggins asking, did he go to the game with eggs on his pants? Did the egg situation happen right before he died? And you heard Ms. Redlick say no, it happened earlier. The location of these vehicles, the location of the eggs, over here on the side. Does it make sense? She would have had to be coming over here, throwing them back this way, then throwing them back over this way, and then back to the front of the parking lot of the driveway. It doesn't make sense. The eggs were in the afternoon. Let's talk about the blood at the scene. The state has charged Ms. Redlick with tampering with the crime scene, and they're arguing that Ms. Redlick tampered with blood evidence, and therefore it's of no value to determining what had happened in the house that night. They offered the testimony of Stuart James. Mr. Wiggins just said on closing argument that the evidence was obliterated. Mr. James was able to opine two expert opinions during his testimony. Number one, that the blood was cleaned up, which is probably something that each of you was able to determine from looking at the photographs. And number two, that he was not able to determine what happened because of the cleanup, that it was impossible. Mr. James agreed with me that he would never be able to give an opinion on why somebody was stabbed, on something that happens before the event that causes the blood. That's not his gig. He doesn't know that. What's in someone's heart, what's in someone's mind, it's not what he's there for. So his job is to help determine what happens after somebody is stabbed. So we can't say anything when we get to second-degree murder, hatred, ill will, spite, none of that. That's not evidence that he would be able to say ever. So we can't talk about why it's happening. He testified that a single stab wound, which is what we have in this case, is not going to create spatter evidence, saying that spatter will come when you repeatedly are hitting a blunt object into blood. So the second stab wound, the third, the fourth, some blunt object. We don't have that here. And we know we don't have that here because we have the autopsy. We have Dr. Zajdowicz's testimony. So if you know there's one stab wound, then you know there's not going to be spatter showing when and where, or showing where, location-wise, the injury occurred. So we know he's not going to be able to determine that from his review. He's looking for evidence of what does the person do after they start bleeding. He said that sometimes, he said that sequencing, meaning laying out an order of events, what happened and when, what order, is something that they can do sometimes, not in every case, whether it's altered or not. He said here that it was impossible to ascertain because the blood had been cleaned up. But you heard on cross-examination that that was not the case. We knew whose blood it was. The blood's Michael's. It's pretty clear. We know the injury that caused the blood. We know he walked around after being stabbed, if you recall the cross-examination. We know this because of the blood trail that goes through the bedroom to the bathroom. We know this because I asked him, is there any evidence that the body was dragged in that area? No. Is there any evidence that the blood was put there by a mop, somehow transporting the blood from the living room or another location into the bedroom? He said, no, that didn't happen. What we have is blood dripping to the ground and then being wiped up. I asked him, is there any evidence or any reason to believe that the injury occurred inside the bathroom? No, there's no evidence of that. The blood, there was no cleanup in the bathroom. The blood that was in the bathroom came from Ms. Redlick cleaning herself up afterwards. The blood that was in the bedroom did not indicate that the injury occurred there. I asked him, is there anything here that makes it look like the injury occurred in the bedroom? He said, no. So I asked him, does the evidence in the case, the blood evidence, your job, what you're here for, support the idea that he's stabbed in the kitchen, walks through the foyer to the bedroom, through the bedroom, to the bathroom door, back out to where he comes to rest in the living room? And he agreed with that. He talked about spatter on the wall near the kitchen. I asked him, what causes spatter on the ground? He says that blood is dripping into other drips of blood or little pools of blood, and it's going to cause that. So he says that by not seeing the pool of blood on the ground, he can't determine what happened there. But he told you how he could determine what happened because he saw the spatter on the walls. That's in the kitchen, right beside where the knife is. So the state's blood expert said that because of the evidence, because of the cleaning, he was not able to tell what happened. But we did a walkthrough in court in front of all of you to show what happened. And that was consistent with what she said happened. The blood evidence on the grounds, in the rooms where it is, supports what she told you. It supports the injury occurring in the kitchen. It supports Michael Redlick then going to the bathroom area where she has run to hide herself. So think about this. Take a minute and think about, why is somebody chasing after her to the bathroom if it's not to continue an attack? What other scenario makes sense there? When we get to the bathroom, you heard Mr. James. He told you about how in June of 2019, when he got this case, when he received the materials and authored a report, that his opinion was that the blood was outside the door of the bathroom, or that a person was dripping from outside. He told you that when we did a deposition in the case in July of 2021, the blood was coming from a person standing outside the bathroom dripping. And he told you that all of a sudden that opinion changed. That opinion changed. I asked him when. He said as he's getting ready for trial. I said when? He said June 5th, so 4 days before he testified. This is the expert who told you he couldn't do anything, but also his opinion keeps changing. What value does that have to the case? The value is that he explained how you analyzed the scene, and we were able to walk him through what happened there, and he agreed with me on what the blood evidence showed. Mr. James said that he can't tell how long somebody's walking around. Clearly, it was not very long. We know that from common sense of what the evidence shows. We know that from the pattern of where he walked. We know that he can't tell really what's going on pathologically for a person after they sustain a wound. That's someone else's job. He said that we don't know who the blood is coming from for some of it. That would have to be DNA testing, but it's pretty clear it was from Michael based on the injury that we have. So Michael's blood all over everything. The state presented DNA experts. The evidence seems pretty clear. Mr. Wiggins just brought up the knife and showed you. This is what he's calling the murder weapon, the knife that was used to stab Michael Redlick. I don't think anybody's disputing that. The DNA from the blood on the scene, on the clothes, on his hands, fingernails, it's his blood. It makes sense. We understand that. She cut herself before the police showed up, but it's not going to cause the blood all over everything in the home. He's bleeding heavily, presumably grabbing his wound, getting blood all over his own hands. She's cleaning up after the fact, blood all over herself, touching things. We know where the blood's coming from. We know whose blood it is. You heard from Dr. Zadovich, the medical examiner, testified, I believe, Monday morning. She performed the autopsy. We heard from her a single stab wound is what killed Michael Redlick, or some scratches, some superficial wounds otherwise, but a single stab wound is what happens here. There's no dispute of any of that. It pierced his lung, caused him to bleed out. Little bruises on his arm, on his side, on his wrist. Not fatal, not contributing to death. Little things, little scratches. Marks on his side, on his arm though, you heard Ms. Conlon ask in cross-examination, is that going to be consistent with someone who's holding somebody down, smothering them? That person's trying to fight out. Are those things you can expect to see in that sort of situation? She said, yeah, sure. You heard her come in and talk about defensive wounds for Mr. Redlick, saying that on his arm there was something on the wrist indicating that it was a defensive wound. You heard during the cross-examination that previously, when asked that exact question, was there any? No, there wasn't. Try and rehabilitate that answer, saying, well, what I meant was I didn't see any like stab wounds in the hands. You heard her testimony. Is this a credible person? And her credibility matters because she was asked, how long is Michael Redlick alive for after he sustains this wound? And so when the state's argument, when their theory of the case is that Ms. Redlick stabs him out of hatred and he's dying as he's bleeding out on the floor and she's watching him apparently, looking at him, not doing anything, how long it takes matters. You heard her on the stand say, I can't tell, I don't know. And she said that the way to know that is from observational data, meaning somebody saw it, somebody filmed it, and you're able to observe what's happening. Not scientific data, not medical science that determines how long this is happening. It's different for every case. When you can put a time on it is when the heart is punctured, is stabbed, but we don't have that here. And then she starts saying, when asked, well, it could be up to hours. Some people have these sorts of injuries and they bleed out in hours. Again, she said this was based on other cases that she's heard about. Nothing to do with this case, nothing to do with this injury, nothing to do with this person. Other things. That's not scientific evidence, that is not medical evidence. But when you hear in this courtroom something like that, it can be important. It can be very important when a major issue in this case is, what is she doing as he is dying? And you heard that testimony on Monday. But then what did you hear this morning when we talked to Detective Ware? You heard that she had made a different statement. You heard that Dr. Zadovich, back when this case first arose, had said he was dead within 5 to 6 minutes. It's a pretty big difference. Why would we have such conflicting inconsistent statements from an expert witness, from a person who did the autopsy on the body. Nothing changed. She's not re-examining the body. State was just mentioning, can you trust this witness? Witness credibility. Weighing the evidence. Did the witness at some point make a statement inconsistent with the testimony he or she gave in court? It's a pretty big one. Yes, she did. And again, the evidence doesn't support that he's alive, that he's awake for any substantial amount of time. Certainly not hours. And why does it not support that? We have a pretty clear trail of where he's walking. It's cleaned, but it's still a trail that shows where he's walking. The blood guy agreed with that evidence. We don't have phone calls from him. We don't have him leaving the home. He's not calling 911 for help. He's not doing anything. So we know that his ability to do anything there, very short-lived. Pretty much follows her to the bathroom and then goes back out to the living room, falls down, and that's all. So when Mr. Wiggins is cross-examining Ms. Redlick yesterday on the stand and keeps asking questions about standing over his body with a phone in her hand, choosing not to call 911, choosing to let him die. Is that what you heard from her? That she was choosing to let him die? Or did you hear something else? Did you hear about what happened in the kitchen? About how she ran away? About how she goes in the bathroom? About how she hears him at the bathroom? He doesn't come in. She doesn't see him. She's hiding in the bathroom, the toilet closet. She doesn't hear him anymore. He walks away. She waits, just like the night before. Right after this attack, waiting until it's safe to come out. She doesn't hear him. She waits a little longer. She walks out, and what does she see? Same thing you see. The blood up to the bathroom door and out to the living room. She follows it. She finds her husband. It's at that point when her entire worldview, her entire reality just crashes. No matter what their relationship was, no matter if she wanted to continue in the marriage, no matter if she wanted to divorce him, believe the state, no matter if she hated him and wanted to kill him. The last time she had seen her husband was in the kitchen. He's got her held down. She stabs him one time with that knife. She runs away from him. She hears him come to the bathroom door, leave. She comes out. He's lying on the ground, not moving. It's going to be a jarring situation for anybody. Why, when she walked out of the bathroom, don't believe me, from the autopsy report, from the doctor, the medical examiner, you heard Mr. Wiggins agree, who would think that that wound is going to kill somebody? Stabbing somebody a single time on a shoulder. She didn't stab him 5 times, 10 times. She didn't shoot somebody one time to get away. She comes back out. He's on the floor, not moving. So she panics. She runs over to him. She attempts to do CPR. She says she couldn't find her phone at that point. He had taken it earlier. We heard that testimony. And we heard about how he was taking it the day before, questioning her, is it your lover boy? Are you making plans with your lover boy? Or in the shower, I'm going to take photos, I'm going to send them to him. We know that that was consistent. He was doing that over those 2 days. She can't find her phone. She's on the ground with him, trying to do CPR. She doesn't know what she's doing. She's not trained. It's easy now, 3.5 years later, to to look at this and say, why do we have a call at 10:52 and nothing else until the next morning? Everybody processes trauma differently. Walking out, finding her husband laying on the ground in a pool of blood, running to him, trying to see if he's breathing, trying to find anything. I asked her several times, is he moving at all? No. Do you have any reaction to anything that you're doing? No, he doesn't. Are you hearing any breathing? No. She calls 911, it doesn't go through. 911. After that, she panics. The weight of the situation is making itself clear. Her husband, the person who has been in her life for 20 years, is a primary figure, the authority figure, the always present figure there, the father of her children, is now dead. No more. He's done. There will not be any more Michael Redlick. And she experiences that and realizes that in that moment. Understanding the trauma that she experiences right there, understanding the reaction that that has to her, understanding what that does to a person, regardless of what led up to it, regardless of the feelings they may have had for that person at the time, it's pretty heavy. And so looking back now, doing a play-by-play of did her reactions, did the things she did afterward make sense? On paper, no, certainly not. She told you on the stand, I made a series of mistakes. I did a bunch of stupid things. She could rationalize that now. But that night, remember her testimony. She doesn't know why she's cleaning. She's going through motions. She sees her husband on the ground, and she had tried to call, it didn't go through, and yeah, would it have made sense to call again? Would it have made sense to walk out the door, go find help? Potentially. But what's important here, there's no evidence, none at all, that he was alive when she came out of that bathroom. There's no evidence at all that he was alive when she was trying to resuscitate or get him to do anything, when she's trying to breathe on him, trying to pound on his stomach or do CPR. There's no evidence of any of that. She was asked, both on direct and on cross-examination. She said no, he wasn't moving, she didn't see anything. Did you think you could save him, was a question. Yes, she's down there trying to. And she realizes it's not happening. She doesn't give up on it. It's become clear to her in that moment that he's not waking up, he's not moving, he's not coming back. So when you're analyzing her actions for the rest of the night, going into the next morning, consider it through that lens, what that does to a person. How that led to her waking up, getting on her phone, Googling how to slit your wrists, doing that, landing in a mental health facility. This is the context of her actions afterwards. We heard about an opening from the state, how they were arguing that Ms. Redlick, after stabbing her husband, was laying next to his body, going through dating apps, going through the Meet Mindful app on her phone. You heard testimony from Mr. Montgomery, the digital forensics gentleman who testified last Friday, that the only way she accessed the entire time she had the phone the Meet Mindful site was through the Safari app, so the web browser on her phone. There was no app that she downloaded separately. He was able to determine this, and you'll get all this evidence. You can review it as well. Through the web history, from the phone extraction. Was able to see that Meet Mindful was accessed on January 12, 2019 at 7:22 in the morning. That's what he testified to on direct. And I asked him, what happened before that? And what did we see? The last web access, January 11th, the afternoon before at 3:24 p.m. This is 17, this is 18, nothing's been edited, nothing's been changed. She doesn't open Safari for 16 hours. And when she does open Safari, it goes into the last 7:22 a.m., goes into the last visited page that she had been at. And we know from the Meet Mindful records, she's not talking to anybody. The owner of the company came in. There was no messages sent that day, nothing done that morning. And we know that because of what she's doing 14 seconds later. Google search slitting lists. I asked Mr. Montgomery, you have an iPhone, you know how it works? He said, yeah. He said, when you close out the browser, but you don't close out the site, and then the next time you open up the browser to go back to the last site that you were on, argued with me about it, but ultimately agreed, yes, that's what it is. I asked him, and that's what happened here. And he argued with me about it, but ultimately agreed, yes, that is clearly what the evidence shows. She was not browsing a dating website while her husband is dead on the floor. The evidence clearly disproves that. That did not happen in this case. It sounds salacious. It's a great headline. It's not true. It's not a fact. It's disproven by the evidence in this case. We don't have evidence before the stabbing that indicates that Ms. Redlick was mad, angry. She was jealous. She had ill will towards him on January 10th or 11th. There's no evidence of any of that. That evidence is all from the other direction. If we know that there's no evidence of that, if we know, if you trust, if you believe her testimony, she sat on that stand for 7 hours, answered questions from myself, from the state, If we know that Michael's the aggressor, that he attacks her, and that she reacts, if we know that she's acting in self-defense, we know that she's justified in the force that she uses, what she does afterward is not relevant for the purpose of the murder charge. It can add context. If you don't believe her, if you think that she's covering up the scene, then sure, that can be used as potential evidence of a depraved mind. But that's guesswork. That's connecting dots for the state. There's no evidence of any of that. She's not on trial for correctly handling the situation. She's not on trial for whether she called into. We know from the testimony, from the supporting evidence, that she wasn't going to save him if she called 911 as soon as she finds him. Use that as context when analyzing this charge. And the state says that she did everything she could to make the scene something else, to make it look like something else. She cleaned up her husband's blood on the floor around his dead body. She deleted text messages. I asked her about that. She wasn't sure why. She was worried about the kids. She didn't know what comes next. The traumatic situation that she's under, the panic. What's the playbook for this? How do people deal with this sort of thing? This doesn't come up in school. This doesn't come up. She's confronted with a situation she clearly was not prepared to handle. Doesn't make her guilty of murder. Doesn't make her guilty of manslaughter. Unless you are convinced beyond a reasonable doubt that she did not act in self-defense, stuff afterward doesn't really matter for that charge. For the tampering charge, sure, that's what she's charged with there. But for the murder charge, her inability to handle what happened afterwards doesn't show anything. It does not in any way disprove self-defense. Part of the state's argument to this point is that she searches, as you saw, how to slit your wrist. She starts doing so. She does so. And says that's consciousness of guilt. She understands she's guilty of a crime, and this proves it. This proves that when she woke up, she knew she was guilty of the crime of murder. Somebody's guilt to a crime is determined in this room, at this time, today. Not on January 11, 2019. Not a magic light bulb that pops up over your head when you do something. When you do an act, it says this was a criminal act versus this was a justified act. The situation she described, altercation, she's attacked, she's held down, she's smothered by her husband. We heard that testimony. Whether or not she's able to defend herself in that time, that's for you guys to determine. What she's waking up and seeing, what she's seeing when she walks out of that bathroom door, is her husband lying on the ground, dead. The reaction to that does not make her a criminal. Does not make her guilty of murder. It argues that the calls she's making afterwards show calculation time, time to think up a story, time to kind of set the stage, set the scene, make up your story, tell everyone what it's going to be. She had 11 hours to do that in the house. She didn't get rid of the knives. They're there on the ground, on the floor, nearby to where the attack happened. She doesn't get rid of his phone. She doesn't leave the home. She doesn't flee, go anywhere. You saw the Google search. You can take that back with you and see all of her web history. There's no searches for how to get rid of body, how to get rid of blood evidence, how to dispose of anything. She testified on direct that there's a lake across the street from her. If you're trying to set the scene, get rid of evidence, it's probably a pretty good place to start. Didn't happen. Came out, she saw the sudden, cold end to a tumultuous marriage laying on the ground, and she couldn't process it. And then her actions afterwards proved that. It said that witnesses Tara Lynn Tucker, Frederick Copeland have no reason to lie. Why is she out talking with them? Where is she speaking with them? She's speaking with them on January 13th, 14th in the Baker Act facility, in the mental health facility where she has been taken because she harmed herself after the events of the night of January 11th. State attorney said that Ms. Tucker has no motivation to lie. Okay, she could have a motivation to do her job, to follow the law, record the conversation, so that we're not forced to rely on her memory of the conversation 3.5 years later when assessing witness credibility. So she comes home from the facility. Her kids are there. She's put in a spot where she needs to explain this to them. Dad's not here. What happened, Mom? That's the situation she finds herself in. And you heard what her daughter said. She said, it's a heart attack. You heard what that did to their relationship. You saw her daughter take the stand. Heard from the jail calls where that relationship stands now. The jail call, Ms. Redlick is talking about the evidence, the state's case. You're talking about how she's dead in the water, but what'd she also say? They're doing motions to prevent self-defense. Those statements are next to each other. I can't use self-defense. If I can't argue that, I don't have anything else, because I did it. I was in the house. I'm the one that stabbed him. If I can't argue this, I don't have anything. Is that consciousness of guilt? Is that understanding the legal situation? You hear a statement in these jail calls where she's talking about what she had spoken with another lawyer at one point when she was in custody. She said she met with him once, it's a consultation. He talked to her about the case, said it wasn't self-defense. She said she told her attorneys that. Seconds later in the same call, you hear her talking about how it was. You hear her talking about how it was self-defense. It was self-defense. Well, these out of context calls.
Objection, Your Honor. Proper argument related to the instruction you read.
Come up. Ladies and gentlemen, I'm going to review an instruction on an edited recording. I instructed you earlier that a recording had been edited to eliminate irrelevant portions that wouldn't add to your understanding of the case. The fact that a recording has been edited shouldn't concern you in any way and must not impact the way you view and consider the evidence. Mr. Parnell?
So what I'm arguing is the call you heard this morning between Ms. Redlick and her sister, where you hear her talking about her conversation with another attorney, where she says the other attorney tells her it's not self-defense. She told her attorney that. Consider the context of that call that you hear, what you hear. Listen to the judge's instructions, follow those instructions. Seconds later is when she's telling her sister, it is self-defense, it is self-defense. Same call. This is the call that Mr. Wiggins told you, the state attorney told you, goes through a different code, a different PIN code, meaning the implication is that she's trying to not have this call discoverable by the prosecution. She uses her own PIN code, they can find it, they can trace it to her, they can use it against her. If she uses someone else's, they'll never find it, she's free to say whatever she wants to say. That's what she's saying. In the private call that she thinks no one else is going to hear. It is so. Don't be confused by that. She talks about the bang-up job that the prosecution has with the evidence in the case. You sat here for 7 days listening to that evidence. Dozens of witnesses. 40,000 pages of phone extractions, videos, interviews. That is a lot of evidence. Part of what you are to consider in these jury instructions, whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. Quality of the evidence, not the quantity. And when there's a lot of quantity, but not much quality, as you heard from the state attorney's argument, doesn't really have evidence of what happened in there. Essentially what you're looking at is asking you to connect the dots and asking you to tell them what happened. State attorney argued that two people's credibility mattered in this case. Everyone else was kind of collateral bit piece, that their testimony, they had no reason not to be accurate, no reason not to trust them. Let's go through some of these people. Carla Sundvall, she was the CST, crime scene technician, who arrives on the scene taking photographs of the home. She's the person who is there for the search warrant, taking hundreds of photographs that you've been provided with in evidence. She's there for the medical examiner's investigator as he investigates the body, turns it over and all that. I asked her, when you see the body turned over, did you notice any injuries on his back? Not a doctor, I can't answer that. Did you see any scratches? I can't say, I don't know. Did you see any stab wounds? It's not really for me to say. So right after she had testified about how she had seen the big stab wound on the shoulder. It's a witness answering questions differently depending on who's asking them. Officer Stanford, responding officer on the scene, sees Ms. Redlick in the house, sees her open the door, cooperative, says she's emotional and distressed, and at the end says, yeah, she's nonchalant about the situation. What are we doing here, guy? Come on. Edward Bigley, crime scene technician, goes to the hospital to take photographs of Miss Redlick, collects the clothing, asked him on the stand, the shirt that you got from Miss Redlick. Can we see it? Can you show it to us? And he does. Asked him if there's any holes in it, any damage to it. He didn't know. Hadn't seen it before. What do we see? Well, big holes in the shirt that appear in the neck area. It's helpful information. Would be good to know. Stuart James, blood guy, talked about him. Evidence changes, or the report, the opinion on key issues changes, not for the first 3.5 years, but a couple days before trial starts. And ask him questions on cross-examination. He agrees with me. State attorney asked him the opposite question, starts agreeing with them. Okay, yeah, you're right. It couldn't tell. It was impossible to tell. Even though we had just gone through an entire walkthrough of the house, an entire reconstruction of what had occurred, and he had agreed with me in that point. This is the guy who made sure to tell you all, I don't consider myself a professional witness. Medical examiner, talked about that one a minute ago. Early on in the case, tells the detective that Michael Redlick bleeds out in 5 or 6 minutes. He's dead within a few minutes. And she testifies in here that I don't know when it could have been. It could have been hours. It's from an expert witness. Credibility is not limited to Ms. Redlick. It's not limited to Jaden Redlick. Everybody that you hear. So when it comes to Jaden, you heard her in court. Simply her testimony is that everything her mother had testified to was a lie. Heard her on the stand, asked about statements she had made. She denied making several times. Here's her voice on the statement. Denies making it. We've heard about that relationship. We've heard about what's happened to that relationship. Heard about her views towards her mother while this case has been pending. You heard her on the stand, asked about knives in the home. Are they all from this one drawer? She said yes. If you notice, while she was giving that answer, literally while giving that answer, you see behind her up on the screen several knives hanging on the side on the wall, magnetically attached. You hear that she doesn't use the drawers in the islands. You hear that she doesn't cook. She doesn't use those drawers. But she comes into court and she tells you the drawers don't work. So the implication there is that Ms. Redlick made up the fact where she got the knife. The implication there is that she came up with this story about what happened, chose to lie to you, made up a story, and told you that she got a knife from a drawer that does not exist. Do we believe that? Do we believe that the person who, in front of you this morning, denied making a statement that you heard her make on the recording, her voice, maybe that person has some sort of bias in this case. Maybe that person has some sort of interest here. It doesn't matter if that's reasonable. It doesn't matter if a teenager's relationship with her mother is destroyed because of this. If you think that's reasonable, maybe it is. Maybe if you lie to your kids about how your husband died, maybe you don't deserve to have a relationship with your daughter. If that's something you think, that's perfectly fine. But where it does matter is when you're analyzing her credibility as a witness in this case. When you're determining, is this a person whose testimony can be trusted? It does matter there. And if that's a reason for that person to not be truthful in court, that's something that you guys should consider. Count 2, tampering. Second count you need to decide on today. Element number 2, did Danielle Redlick alter, destroy, conceal, or remove any record, document, or thing with the purpose to impair its verity or availability in the investigation or proceeding? This is asking is, what is the purpose of what she's doing? You heard her testimony on that. You can determine her credibility. Is she trying to destroy evidence? Is she trying to create a scene for law enforcement? So, why is she leaving the knife? She's not getting rid of other things, the phone. Why is she sticking around? And as for the murder charge and the manslaughter charge, you have a copy of this, but we'll go through it here. It's important. The use of deadly force is justifiable if Danielle Redlick reasonably believed the force was necessary to prevent imminent death or great bodily harm to herself while resisting another's attempt to murder her or any attempt to commit manslaughter, aggravated battery, or aggravated assault upon her, or any attempt to commit those same offenses upon or in any dwelling in which she was present. Danielle Redlick was justified in using deadly force if she reasonably believed that such force was necessary to prevent imminent death or great bodily harm to herself, or the imminent commission of manslaughter, aggravated battery, aggravated assault against herself. If Ms. Redlick was not otherwise engaged in criminal activity and was in a place that she had a right to be, then she had no duty to retreat and had the right to stand her ground. If you find that Danielle Redlick, who, because of threats or prior difficulties with Michael Redlick, had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Michael Redlick, you may consider this fact in determining whether the actions of Danielle Redlick were those of a reasonable person. If you find that at the time of the alleged second-degree murder or manslaughter, that Danielle Redlick knew that Michael Redlick had committed an act or acts of violence, you may consider that fact in determining whether Danielle Redlick reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Danielle Redlick and Michael Redlick. This means a few things. Number one, everything that she experienced up to that day in their relationship, it mattered. Why did it matter? Because it informed her fear at the time that her husband was attacking her. She knew what he'd done to her before. She knew the look in his eyes. She knew when she sees that happening, Michael's gone. This is something else. This is something evil. This is something dangerous. This is something that's going to hurt me again. That's what she saw that day. From her own experience, she remembers what's happened. She can tell this time it's worse. This time he's angrier than he's ever been. That's not just her words, that's her daughter's words too. You hear that she did not have a duty to retreat. There is no law requiring her to get away, to try to get away from him. You heard that she tried. She's struggling underneath him. She's pinned. She's trapped. She's unable to move. But the law does not require that she do that. Even though she's trying to, it's not required. She doesn't have to run out the door, run to the corner, and wait until her back's up against the wall. That is not the law that's in front of you. And that man stopping her from breathing, pressing her up against the island, has his hands on her face. She pulls out the knife, she grabs the knife, and he re-engages, grabs his hand. Back goes her face, down comes the knife. She doesn't have to get away there. The only way that she's able to escape is by doing what she did. And we know that her goal was to escape because she stabbed him one time. If she's stabbing him out of hatred, ill will, spite, probably seeing more than one stab wound there. It's probably not to the shoulder. She's probably not running to the bathroom. Is her belief reasonable? The question is not if anyone is put in that situation, do they think it's reasonable? The question is her in that spot, with her life experiences, her experiences with her husband, is it reasonable for her at that point to feel that great bodily harm or death is coming to her if she doesn't act? You'll see these instructions.
15 minutes.
Okay, thank you, Judge. As to what she can defend against. He's trying to kill her, the same instructions that you see on the second-degree murder. If the evidence shows you his actions over those 2 days led to what she testified to. His increasing rage, his anger, his violence, alcohol. That has all led to what she described. She reasonably believes at that point, while she can't breathe, while she's trapped and pinned against the island in the middle of her home, that she's going to die. And yes, absolutely, she's justified in using deadly force. If you think that it's not reasonable that she thought she was going to die, you look at aggravated battery. Michael Redlick actually and intentionally touched or struck Danielle Redlick against her will. Michael Redlick, in committing the battery, intentionally or knowingly caused great bodily harm to Danielle Redlick. What this says is, if it happens or if there's an attempt, it does not require, the law in Florida does not ever require that a person take the first blow, that they get hit first before they can defend themselves. She doesn't have to have a broken bone or scarring or concussion, anything like that before she's allowed to defend herself. Why? Because if that's what the law required, she's not going to get the chance to defend herself. So if the state gets up here and argues that the injuries that she sustained, the bruising on her arm, which is consistent with being pressed up against the kitchen island, the injuries to her knees, which are consistent with being hit in the head, going down, before she's dragged up by the hair and placed on the island, the injuries she complained about on the side of her head, where she's held down like this by her husband as he's covering her face. If the state attorney tells you, or if you're thinking yourself, those injuries aren't good enough to prove that she needed to use justifiable force, it's not what the law requires. She doesn't have to have injuries to be in fear of that man. She just has to reasonably believe his violent attack against her is going to cause death, great bodily harm. Remember the scene the night before. The events from the night before causing her 12-year-old son to text her like this as she's sneaking back into her own home to avoid her husband. That's the sort of fear that we're dealing with here. We know that the next day was similar because we walked through all of the evidence of what Michael was doing that day. We know he was mad, we listened to voicemails. We know he was following her around. We know that he was drinking. We know that on Thursday, his daughter had taken the vodka bottle and thrown it out in the dumpster outside, per her own testimony. We know that on Saturday morning, when the police arrive, they find another vodka bottle, presumably the same one you see in the video, in the kitchen garbage can. We know that his blood alcohol content is 0.09, above the legal limit to drive a car. One difference between the fear that we see the night before and what we see the next night is that what got in the way, her kids, they were gone. You heard Ms. Redlick testify. When she's home, she has a McDonald's. He grabs the phone, says, "Why don't you go out with your boyfriend?" She says, "Maybe I will go out with him." And that switch just snaps. That rage, it's there. That danger, it's not Michael anymore, it's something else, that's there. That reaction to insecurities, to ego, to pride, that ownership, controlling, it's all right there in that moment. It's there in that moment when he begins attacking her. It's there in the moment when he pins her up against the kitchen island. It's there in the moment he snaps her head back. It's there in the moment when she brings that knife forward. She's not guilty. She did what she had to do to escape the situation.
Quick break and 15 minutes, and then we'll come back.
going to begin my rebuttal by addressing a number of the points that defense counsel made through his argument. Defense counsel said that the state of Florida has come before you and pointed to the email on May 18th, 2018 as evidence of a plan. I would hope that I was clear in that you know that at no point has the state of Florida said that this is a plan that she is laying out. It is, however, predictive and, in hindsight, significant. And in looking back at what happened and looking back at that email and comparing, it illuminates Ms. Redlick's head, where her mind was, what she was thinking, and likely some of her motivations for the decisions that she made. Nor did the state argue to you that she was so upset about the cheating that she decided to kill him. You never heard me make that argument. I never made that argument. In fact, the argument that I made to you folks is that the state of Florida is unable to definitively say why she killed Michael. And defense counsel got up and they said, well, the state's theory sort of lacks, but we can tell you what happened. And the state of Florida, in every homicide case, finds itself in the position of not being able to call the victim and have the victim explain what happened. And in this case, the theories and explanations that the defense has advanced in each and every instance rely on putting a shred of credibility and stock into what comes out of Ms. Redlick's mouth. And even further, everything that she does following the murder of her husband to alter, change, and modify the scene. It puts the state of Florida in position both because everything comes from someone who is an admitted liar and who endeavored to modify the scene from corner to corner to try to understand, to try to be able to explain to you what happened. But that's because of Ms. Redlick. When we do look at the scene, we see that conflicts begin to emerge from Ms. Redlick's testimony. Or if they're not conflicts, the evidence or the absence of evidence sheds such a further light on the efforts that she undertook. Because we think to where Ms. Redlick says this incident took place, which is it starts right there by that island where she stabs him. And you heard from the medical examiner that injury punctures or severs this basilic vein, and that blood is coming. This is a highly active bloodletting event. And you look in that space, and there's just the smallest amounts of blood. There are those bloody footprints. There's the diluted blood on the sink. There's those strange sort of traces of blood on the counter, but that's it. So right there in the center of where Ms. Redlick says this incident starts, there's almost no evidence of blood. Is that because it didn't happen there? Or is that because that's where Ms. Redlick starts her cleanup and spends the most time and focus in modifying the scene? The state can't tell you, and the state can't tell you because this defendant's choices. And each one of those choices, you understand, are motivated out of self-interest. Defense talked about the blood and the blood testimony and issues that he has taken with Mr. James's opinions. But he talks about the blood trail and how the blood trail somehow corroborates or supports the account of Ms. Redlick. Because what Ms. Redlick says happens is that she stabs Michael and they sort of go their separate ways. And she goes to this toilet closet thing, the toilet inside the bathroom, and Michael follows or must go to the bathroom, right? We know that both from her testimony to the extent that it can be believed, but from the physical evidence. And Mr. Parnell came before you and he argued that, well, what does that show you? What is that consistent with? Can you come up with any other explanation other than he is continuing the attack? He is continuing to chase her. Well, I can come up with another explanation, that Michael has just been stabbed by his wife. He's been stabbed, and he's holding his shoulder, and this injury that doesn't seem all that significant is bleeding, and he is taking stock of what just happened. And he is looking around, and his wife is nowhere to be found, and he walks to and towards the bathroom. Now, the image of Mr. Redlick in this moment that has been painted for him is one of homicidal rage. He is sort of gone dead behind the eyes, and he is attacking her viciously and savagely. And that Mr. Parnell just told you that this is part of the attack. He is following her. But look at what the evidence shows. What do you know about that door? Well, you know it's broken. We know that it was broken before the incident. That's all we know for sure. Ms. Redlick says it was broken on the 10th. Jaden says that's not possible, didn't happen. But we know it was broken before this incident. This man who is possessed with just literally a homicidal rage doesn't go in the door. In fact, more than just he doesn't even go in the door, he doesn't touch the door. We spent some time on direct examination looking at those photos, and we talked about the exterior of the door. We talked about it with both CST Sunval, and we talked about it with the blood stain expert. There is no blood to be seen on the exterior of that door, nothing on the handle, nothing on the door itself. So this image of this man who's been stabbed, he's in a rage, and he follows her to a door that can't be locked. And he's stopped by it. How? Well, it's not the lock that stops him. And for some reason, the door that can't be locked, for the woman that he is bound and determined to continue to attack, he doesn't even reach out with it. This is not speculation. This requires just use of common sense. You have been stabbed. It's in a vein that will eventually bleed with such volume that you die. The natural human reaction, everyone is going to do this. You're going to touch where you've been hurt. You're going to touch where you've been hurt, and you're going to have blood on your hands. The idea that this man follows her in this rage, comes to a door that cannot be locked, and doesn't even touch the door, shows you how when you begin to really break Ms. Redlick's story down with the available physical evidence, that it starts to fall apart. It was some time focused on the medical examiner's testimony and the estimate that she provided about how long it took Michael to die. If you think back to the argument that I made, I never once cited the medical examiner. Because what the medical examiner thinks about Michael's time of death, how long it took him to bleed out, is completely irrelevant. It's irrelevant. Why is it irrelevant? Well, it's because the focus of this point is not when precisely did Michael die? Could he in fact have been saved? The focus is on her perspective. It's her perspective that matters, because what she told you is what she believed when she saw Michael, which she believed that there was still a chance to save him, that she believed that I could perform CPR and somehow make a difference. Had Michael been dead for 15 minutes? Maybe. Had he been dead for 5? Maybe. Did he live for another hour? Maybe. That doesn't matter. What matters is, for the significance of this decision, is that Ms. Redlick, and to be very clear what she said, had already found her phone and looked upon that man and thought that he could be saved. And what did she do? She attempted CPR for the first time in her very life. That shows you her perspective. Because she believed that, it doesn't matter what the medical examiner says. Because she believed that and she made the choice not to call 911, it tells you so much about every decision she was making, about what she was really willing to let happen in that moment. She was willing, once again, to prioritize her own interests over the life of a man she thought could still be saved. There was a discussion about the Meet Mindful records. Let's be very clear about the significance of the Meet Mindful records. Ms. Redlick is not guilty of this murder because she joined a dating website. She's not guilty of this murder because on the morning that she woke up, her phone, Ms. Redlick, accessed the dating website. The state has never argued that. The significance of that moment in time is because of, when you look backwards, what it tells you about Ms. Redlick and what she wanted and the life she wished to live. The state of Florida was precise in its language when it delivered the opening statement. The evidence is clear. Ms. Redlick was on that dating website. What they would like you, their interpretation of the evidence is that she opened it and she had no interactions with it, and she went on to slitting her wrists. The evidence is clear that whatever activity occurred on that website, it could only have been for 14 seconds. However, the state of Florida did not make this point without doing the research and without pursuing it to see if there was some substance that this was more than just Safari opening up. And what you heard from the Meet Mindful owner-operator, because you have to look at the actual records itself, is that you have two data points. You have two activities within the app. So you have actually an action occurring on two occasions, not just a single load and then switching off. App opened, viewed conversations. App opened, viewed conversations. That doesn't take long, and it doesn't mean she's guilty. But the state of Florida supported this position with evidence, and you get to determine what it means, the overall guilt of Ms. Redlick. Never said that she was sending messages, never said that she was, swiping right on profiles or left or whatever it is. But in fact, she's there, she's on it, you have these multiple entries. But it really is about December 5th, separated, and what that meant about where Ms. Redlick wanted to be and the life that she wanted to live. The fact that Ms. Redlick could not complete her tampering efforts, the fact that she couldn't remove all the blood and get rid of all the evidence doesn't make it any less tampering. I mean, the fact that it was a fool's errand and destined to fail doesn't change the significance of the effort itself. So just because it wasn't a good effort, just because it wasn't a complete effort, doesn't mean you're able to tell from that decision what was motivating her. So let's talk about the multiple Danielle Redlicks you've met through this trial. You have the Danielle Redlick that you have heard throughout the course of the number of statements she made, recorded and unrecorded, through the investigation phase. That's the Danielle Redlick who said Michael Redlick killed himself. You have the Danielle Redlick who appeared before you at trial and said, no, in fact, I killed Mr. Redlick. And then you had a third Danielle Redlick. You had a Danielle Redlick that you heard in those jail calls. And the state of Florida offered two sets of jail calls, the actual PIN calls and the alternative PIN calls. And they're important for a number of reasons. I talked about how in the call with Jaden, she admits that she lied, and she lied because she knew that she might get arrested. She also, in that call, makes a comment about how she has to be careful because she's on this phone. And she's expressing an awareness of the fact that she's being recorded and that she knows that we're going to hear every call that she initiates and participates in while she's in the jail. And then you have the alternative PIN calls. And you hear a different person. You hear a person who is talking openly about the prospects of her case. She says, this is with her sister, "This is a confidential call. As far as I know, right now, don't ask how. Whatever we can say, I'm saying if you couldn't, I can't, I need to know how to handle this plea." So she's telling her sister it's a confidential call. And in that confidential call, she makes some statements that you can guarantee that if she had made them in her regular PIN calls, you would also heard them, which is that I'm dead in the water all the way around. She is reflecting on this case and how strong this case is. Danielle Redlick talks about how dead in the water she is. And you'll hear it, you can listen to it, you can hear it in context, and determine the true weight of that statement. Whether she's just talking about motions that are being filed or a reflection of how truly dead in the water she knows she is, because she knows the truth. She says, "I'm praying on no prison time. Maybe I'm praying for the wrong thing." State of Florida submits to you that is a consciousness of the fact that Ms. Redlick realizes that exoneration is not in the cards for these facts. And she does, in fact, refer to the state's case as a bang-up and untouchable job. But in that call, she begins to talk about the facts. She talks about the dating app. She talks about a number of those activities that she engaged in, and she pulls back a little bit in that call. You'll hear her say, she starts talking about the dating app, she starts talking about some other aspects of it, and she goes, "I don't want to risk too much." Because, I mean, she's not a dumb woman. She probably has some awareness that this is maybe not a foolproof plan, that maybe we could find calls on other pins. And so, although she is far more open, she still realizes that there's this possibility that one day she'll be sitting there, I'll be standing here, and you'll be hearing something. So we're not getting just the most free-flowing open conversation. There's still this expression of reservation, but it is so far different than what you hear in that other call when she says, "I'm dead in the water." And then you have the fourth call that's in evidence as states 65. So once again, Ms. Redlick is exercising this alternative PIN. And let's focus on what she says at the start of the call and what it says about Ms. Redlick and what Ms. Redlick is willing and able and interested in doing. She says, "Jim Taylor gave a statement, right? But Jim loves me too. I'm talking to him in jail now." And he's like, "Danielle, I'm just telling you, no judgment. And if he had said that to me in the office, and okay, Jim, you made this statement about the steak knives. I could have said, Jim, that's not going to help. I could have had a conversation with people. Not to lie, to say, look, you're going under oath. Look, you know Michael. I could have had conversations. You know what I mean?" She is talking about the fact that she's aware of this fact this guy, Jim Taylor, has given an interview, that Jim Taylor has said something about steak knives, and she believes that it is bad for her case. She's saying that if she had been on the outside, she could have got to Jim Taylor, not to tell him to lie, but, kind of talk to him. Tell him, look, you know Michael. She is talking about, in this moment, how if she had had the opportunity, she would shape witness testimony. She would influence the outcome. She'd get witnesses to change or shift what they have to say so she can avoid responsibility. That's what she says. That is who Ms. Redlick is. That is what she says she's willing to do in this confidential call. Then there's the exchange about Eric Barker. Listen to it, because it is significant it is significant. She says, Eric Barker was the first one that told me. This is who she consulted with about her case, divulged the facts of her case to. I don't know if this looks like self-defense. You might have to reposition this. So think about that. Ms. Redlick has met with this attorney. She's talked about her case, and this attorney has said, the story that you're providing me does not sound like self-defense. This is in May of 2019. He knew that right from the beginning, and I told my lawyer that. I'm reading from the call.
Reading from the call?
I've transcribed the call, so I'm reading.
What exhibit?
Exhibit 65.
So I withdraw the objection. I thought he was making further argument on something.
Okay. Objections overruled, or you've withdrawn it? Okay. Mr. Wiggins, you can continue.
She goes on to say, he knew that right from the beginning. I told my lawyer that. She goes on. My lawyer now is sitting with them, telling them that it is not self-defense. I already told them, I told them this months ago. I already told them this months ago. So whatever story Ms. Redlick has at this point, it ain't self-defense yet. And that they're going to have to reposition it, and she is divulging in this moment that what she's saying, what she's prepared to offer at this moment, it ain't self-defense. And the lawyer she consulted with told her that, and the lawyer she has now, she's also relayed that to. She is telling you that the story that she's telling, she knows, is not self-defense. And they're going to have to reposition. They're going to have to come up with a better story, is the implication. Now, what you hear next is really significant because her sister goes on and Danielle responds, her sister's like, you're going to have to take your chance with a jury and face the consequence if you get convicted, paraphrasing. And Ms. Redlick says, I don't think I'll get life in prison. It's not second degree. It's not second degree murder. You don't murder someone in the armpit. Let's think about what Ms. Redlick is saying there. Ms. Redlick is not saying, I'm not guilty. She's not saying, I acted in self-defense. She is saying, you will not find her guilty of second-degree murder. She is saying, I think a jury will hear this, and they'll only convict me of manslaughter. Because for some reason, Ms. Redlick's understanding of second-degree murder at this point, she thinks that you couldn't be convicted of second-degree murder if you stab someone in the armpit. But we know that's not true. So Ms. Redlick in this call is talking about her future jury and how her future jury will see these facts and that they won't come back on second because the second can't be in the armpit. Think about that. Those are the words of a guilty person. Those are the words of a person who at the very least is acknowledging that the facts and evidence are sufficient to convict her of manslaughter with a weapon. And those are the statements of a person who doesn't understand the law and realize that the armpit is quite a viable avenue for a conviction of second-degree murder. So you hear in this moment, Ms. Redlick is, when you really understand it and break it down, admitting that she's guilty. She's admitting that she's guilty. She's admitting that at this moment in time, she does not have a viable story. But she knows she's being recorded. And so she does say at the end of the call that it was self-defense. But you have to listen to what she says. Because what she actually says is there was more of a struggle or something. So when she says it's self-defense, she goes, it's more of a struggle or something. So the absolutely brutal attack, the attack that she says put her in a position where she had to use deadly force, in this moment, it's a struggle or something. That's how she describes what occurred to her. A struggle or something. And nowhere in that instruction about self-defense does it say you get to kill someone, you get to use deadly force because of a struggle or something. Those are Miss Redlick's words. Those are the words she hoped you would never hear. And you've heard them. So, let's set aside everything Miss Redlick has ever said. And let's look at the physical evidence that's available. And only from the physical evidence alone, you will see that Miss Redlick's claims are without support. Let's assume that that drawer is not decorative. Let's assume that there is a knife in that drawer. So, let's start with our injuries. We have Michael's injuries. We have an incised wound to his eyebrow. You could be forgiven if you had forgotten about that because you don't ever hear defense mission. And we have the contusions to his chest, and we have the stab wound, because it's always one stab wound, never ever a reference to the other injuries caused by a sharp object. The zone of contusions, the superficial incised wound to the side, and the additional contusion on the arm. This is what Mr. Redlick looked like. This is what he looked like when he entered the medical examiner in his dirty state. This is what he looked like when he was cleaned. You can see the wound here, the wound here. You can see the bruising in his arm. You can see that incised wound caused by a sharp object, bruising to his temple. Closer up. The wound, the bruises. A better picture of the bruises down his arm. Closer. His forearm with that injury that's consistent with having your arms up and sustaining some sort of blunt trauma. The injury inside his lip. This incised wound, this wound caused by a sharp object, a knife, to his side. So then we see Michael's condition. And we look at Danielle's condition. This is, other than her self-inflicted wounds, this is her arm. This is the only injury that she identifies to the initial responding officer. Okay? And this is, once again, at the hospital, the only injury she identifies to Officer Galloway, who's there when she arrives. Other than, of course, her wrist. So if we just step back and we look at this and we don't even think about what Ms. Redlick has said, and we compare the condition of these two people, who looks like they've been attacked? Who looks like they are far worse for the wear? Mr. Redlick. Mr. Redlick is bruised all the way up his arm, to his chest, to his mouth, to his temple. He's been stabbed. He's been cut. He's been cut. Miss Redlick has a bruise to the side of her arm. Now, you don't have to rely on just the photos. You heard from the medical examiner. I'm sorry, not medical examiner, the ER doctor. Let me stop here to say this. There was an audio issue, a little bit of an audio issue sort of at the front end of that ER doctor's testimony. That's a disc that's in evidence. It's not a disc that can come back to you. You're going to get a list of the things that can come back and can't come back. If you wanted to hear her testimony again, you could request that and we can make arrangements for you to hear it. So if there was any, your recollection, my representations aren't sufficient on this particular point. I'll also tell you at this juncture, just to get out ahead of something that we experience quite often, you've heard about police reports and all number of documents and stuff throughout this case. If an item is not in evidence, if it wasn't admitted through the course of this trial, it's not available to you. So you don't get police reports, you don't get transcripts, you don't get things like that. So just know, it just happens so often that I want to just let you all folks know about what you can expect as far as the exhibits are concerned. But you can listen to Dr. Vandervelt's testimony again if you want to. But you could just rely on the medical records. Because it's important to think about the timing of these statements by Ms. Redlick. We've had what she says on scene. We have what she says because Galloway beats her to the hospital. And then we know from Galloway's card that basically he's taking photos right when Dr. Vandervelde is doing this initial evaluation, okay? And during these first moments, during the point in time where Michael has killed himself, where she doesn't have to have a self-defense story, this is what she tells you. Denies head trauma. That's quite a bit different than what she said in court. And loss of consciousness. So in the outset, when it's not self-defense, when Michael killed himself, she denies head trauma. All this punching and slamming and violence and rage that she's describing, she's denying it. And then we actually, because this is sort of the triage notes, we don't have to rely on someone else. We have actually what occurred during the evaluation, point by point. She's, generally speaking, no acute distress. Her head, this ER doctor with all her years of experience who told you she's not just taking the patient's word for it, she is getting history, but she's also performing her own evaluation, atraumatic, no trauma to the head. Ms. Redlick is not reporting any injuries to her head. Her neck is supple. There's no issues. For a woman who's come in here and told you she's ripped up by her hair, she's thrown to the stove, the neck without issues. And then there's the back and the musculoskeletal. And this is why I spent the time that I did on cross-examination trying to draw out the specifics of Ms. Redlick's claims in some significant detail. Is because Ms. Redlick is describing a 240-pound man who wants to kill her, she thinks, who the physicality of this is consistent with this man wanting to kill her, who is straddling her, who is forcing her violently against this kitchen island. And she talks about how at some point when she's on her side, I suspect because she needs to account for the bruise, but at some point she is back like this, and she has that edge of that counter pushed into her. And this man is literally trying to kill her. And when she goes to the doctor, there's no tenderness. And the doctor even talked about it. I said, well, do you just take her word for it? And she talks about, no, I actually palpitated her back. So she went and actually touched her back, and Ms. Redlick confirms that she had no tenderness in that area. And then musculoskeletal. There's normal range of motion, normal strength, normal, no tenderness. I asked, how broad is that? She goes, that's everywhere but what I list. So head to toe, Miss Redlick, in this early stage, when the story is suicide, has no injuries. Has no injuries. And then you compare that against what she's described, and you realize it's not adding up. And I'm not saying that she has to have sufficient injuries. No, you don't have to wait till someone injures you to kill them or to act with injustifiable deadly force. But afterwards, when you're in trial and a jury is instructed that you should look at the physical evidence, and does the physical evidence agree with the testimony, and you see basically from top to bottom, she's not injured, you realize that there's something really amiss. And then a curious thing happens. She's told the reporting officer, just here. She told the second officer, just here. She told the ER doctor, just here. And then for some reason, late in the afternoon, she starts talking about things to her head and elsewhere on her body and her knees. So it appears that at some point, Miss Redlick realized, I'm gonna have to come up with, I gotta have something to say. But it's interesting what she says. She says that when she points to her head, she can't point to her face, she can't point to her neck, she like kind of moves her hair. She points to areas that you can't refute with the physical appearance. And then the story develops. On the phone, she says choking. Well, she knows she doesn't have bruises to her neck. So when she gets before Terrell and Tucker, she gets before you, she says two really curious things. She says that Michael put his hands over her mouth. Put his hands over her mouth. That's what he was doing. That's how he was trying to smother her. And Michael didn't punch her, he did this. Why? Because she can't say that she was choked. And she can't say that she was punched because she knows she doesn't have the physical evidence to support that. So she has to construct a story that matches the physical evidence the best that she can. She has to find a way to fit the facts to her story. And then we look at Michael's physical condition. Over and over again, you are told by defense, she only stabbed him one time. And you just use the word stab very literally, and I guess that's correct. There's stab and there's incised. Danielle Redlick gets on the witness stand, puts her credibility at issue, and she takes this opportunity to tell you why she killed Michael Redlick, and she gives you play-by-play, everything that happened. And she knows those injuries are there. She knows that his eye is cut with a knife and his side is cut with a knife. Defense counsel knows his eye is cut with a knife and his side is cut with a knife. And she is not asked a single question about that. Not a single solitary question about how Michael gets cut in the eye and how Michael gets cut on the side. Whoa. Not a word out of her mouth that accounts for two other occasions where she takes that knife and she reaches it out and she cuts Michael. She cuts Michael in the face, she cuts Michael on the side, and she stabs Michael. And where did you hear that from her? Nowhere. Why? Why? Play by play, every nitty-gritty detail of what she did to save her own life. And she says nary a word about the two other times that she used a knife on Michael. Defense counsel gets up an opening and through this entire case, and it's like it does not exist. Why? Because she can't make it fit. She can't make those injuries fit with her story. Because if she's got the knife and she's slicing at his face and she's slicing at his side and then she stabs him in the shoulder, that's a whole different ballgame. That's cut a man on top of you, you reach up and you cut him. The irrefutable physical evidence is completely contradictory to the story she told you. She can give you no answer for those injuries because to admit how those came about is to admit her guilt. But what about the other injuries to him? Not even just the cuts. Do we hear anything to explain why his lip is busted, why his temple has a bruise, why his chest is bruised, why his arm is bruised? You didn't hear a single word to account for every other injury on his body. Why? Because that does not fit with her story. It doesn't fit with her account. And they don't even try to explain it. You're told. You look at the physical evidence, you compare it to the testimony. And when you do that, Miss Redlick's version of events absolutely and utterly collapses. And then when you think about it, her testimony is completely refuted by the physical evidence, and you step back and you look at it all and you go, it's because she's guilty. It's because she did this. And try as she might, trying to construct a story that will fit 3.5 years and all this time, she can't do it. She came before you. She raised her right hand and she swore this was the time she was telling the truth. This was the time. This was the time for her to tell her story. When she tells that story, she leaves out significant and critical details because she's got no way. She's got no way to make it work. And so she is who she says she is. She is a person who will lie, try to influence witnesses, and do whatever she can to avoid responsibility. Today that ends.
Ladies and gentlemen, if you can turn to your jury instructions at this time, we're going to start on page 20. hear a recording or you have heard a recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you listen to and consider the evidence. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and I'm going to show you now what they are. You don't have those in your packet. You're going to get 3 pieces of paper as part of the exhibit. As part of the verdict. The first one says State of Florida versus Danielle Redlick. It gives the case number, the division number, and the charge. And it reads, verdict as to count 1. We, the jury, find the defendant guilty of second-degree murder as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant not guilty. So say we all dated at Orlando, Orange County, Florida on this blank day of blank 2022. So this is how it looks. And what you're going to do is for one of the 3 blanks here, you're going to put a check mark or an X by what your unanimous verdict is. The foreperson will sign and date it. If you find that the defendant is guilty of second-degree murder or of manslaughter, then you must consider the special finding form and determine whether the defendant carried, displayed, used, threatened to use, or attempt to use a weapon. And so it looks pretty much the same. It'll say special finding. Answer if you find the defendant guilty of second-degree murder or manslaughter. And then there are 2 sections that you need to consider. The first one says, we, the jury, find the defendant during the commission of said offense personally did carry, display, use, threaten to use, or attempt to use a weapon. And the next consideration is, we, the jury, find the defendant during the commission of said offense personally did not carry, display, use, threaten to use, or attempt to use a weapon. So say we all dated, place for the foreperson to sign and date. For those 2 sections, you're going to select whatever your unanimous verdict is. The third page is the verdict form for count 2, tampering with physical evidence. And it says, we, the jury, find the defendant guilty of tampering with physical evidence as charged in the information, or we, the jury, find the defendant not guilty. And your foreperson will sign and date that. And so that will go back with the exhibits and the. So let's turn to page 24, please. Submitting the case to the jury. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when you all have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case until you have reached a verdict. You must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices in the jury room. Kindly leave those devices with the court deputy, who will guard them while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in your note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. If, however, you wish to see the following exhibits, please request that in writing. Exhibit 13, video testimony of Mr. Utsi. Exhibit 14, a laptop. Exhibit 17, video testimony of Dr. Vandervelde. Exhibit 23, a second laptop. Exhibits 28 through 31, knives. And Exhibit 34, defendant's cell phone. The remaining exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. That's it. Okay. And so with that, the following jurors who are our alternates will remain seated while the other 6 go back to deliberate. Juror number 294 and juror number 309. 294 and 309, I need you to sit back and wait for me. And the other 6, please take your notebooks, your jury instructions, and the deputy will escort you to the jury room. I will let you know that it's going to take us a little bit to gather the exhibits that need to go back. So you can go on and select your 4-person, take a break to refresh yourselves, and as soon as the attorneys go through the exhibits to make sure the right ones are going back, the deputy will bring the exhibits, the jury instructions, and the verdict form to you. Okay, and with that, you are excused. Okay, for jurors number 294 and 309, you get all the way through spending almost 2 weeks with us, and then you don't get to deliberate, and I don't want you to think that your service was for naught, because it wasn't. An alternate acts as a safety net for us. Because the trial lasted from last Monday through today, anything could have happened in that time frame where individuals get sick or they have to leave or something to that effect. We needed to have 6 jurors to go back in order for us to go forward with the case. Otherwise, a mistrial would have resulted. But you two were the safety net. In the event that something happened, you would have been able to step in and serve as the replacement. But I do want to thank you both very much for your participation in this process. And I hope that the next time you get your jury service summons, when you hear that question, how many of you were excited about getting your summons, you can actually say, well, yeah, maybe me. But if not, I do hope that you have at least learned a lot about the judicial process and how important jurors are to the criminal justice system. Because without you, we could not have jury trials. And so with that, on behalf of the Chief Judge of this circuit, Lisa Munyon, and all of us here, thank you very much for your service. You are excused.
Do we leave our notebooks here?
Yes, sir. Thank you.
Yes. Yes.
Counsel, can I get you to come up with Betsy and look at the exhibits and make sure the right ones are going back? And we will be in recess until we have a question or a verdict. go back on the record. Okay, so we are back on the record. It's a little bit before 8 o'clock. And what I plan to do was to recess at 8. But if they are close in their deliberations and feel like they can finish tonight, then I don't have any problem staying, and I probably would prefer to stay, even though it's hot in here, because the AC is off. What time do they eat? 7? Okay. Let me see where they are at 8 o'clock. I know we're just a little bit early, but at about 7 minutes, I'll check and see where they are. Ms. Redlick can go on and just stay up here. There's no sense in taking her back down.
She's been up here.
Oh, she has been up here in the back? Okay, well, then she can just stay in the courtroom. There's no problem for her to just sit there with her counsel. All right, so we're going to be off the record until I can find out where the jury is. All right, thank you. Okay, so it's 8 o'clock now. We've been here for about 2 hours. Let me just state the obvious. The air conditioner is off. I can't imagine what it feels like in there. So I've asked facilities to turn it back on, but what I wanted to know is, I'm not trying to rush you at all, but because it's 8 o'clock, do you want to stay and continue, or we can break tonight and we can come back tomorrow morning at 9? It's going to be up to you to let me know what your pleasure is. Rather stay? Or do y'all want to step outside and then decide what you want to do? How about I let you all step in there? Y'all tell me what you want to do, figure out what you want to do, and then y'all come back and let me know.
Are we exiting?
We'll give them a minute to figure out what they want to do. Okay, what's your pleasure? Come back in the morning. All right, well then I will see all of you here tomorrow morning at 9. And once again, you all probably can repeat it to me now. Don't watch the news coverage of the case. Don't do any research online. Don't talk to anyone about the case. Don't allow anyone to talk with you. Don't go to any of the places that have been mentioned in the course of the trial. Don't research the people, places, things, all of the nouns related to this. And I'll see you all tomorrow morning. What's going to happen, instead of you all coming in here, you're just going to go straight to the deliberation room, but the deputy will let me know when all 6 of you were here so that I will know, okay, they have started up again. So with that, everyone stay safe, have a good night, and see you tomorrow. You're welcome. Nine o'clock tomorrow, everyone. Have a good night. Stay safe. We are adjourned for the evening.